Yea. All persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting in Boston within the Commonwealth. Your unanimous tendency shall be heard. Now sit in the Commonwealth of Massachusetts. Court is open. Please be seated.
Good morning, everyone. Welcome to the Appeals Court. I am Justice Rubin, and I am joined today by my two excellent colleagues. To my right, Justice Nyman. To my left, Justice Walsh. We will be hearing 6 cases this morning, and we'll be starting a little out of order, hearing what was supposed to be the second case first. For those of you who are not familiar with our procedure, it's 15 minutes per side, and there's no rebuttal. We have read your briefs with some care and are very familiar with the facts. So my recommendation would be to get right into your arguments. However, it is your time, and you may do with it as you wish. Having said that, our first case this morning is number 22-562, Commonwealth versus Snow, and we will hear first, I believe, from Mr. Chirakas. Is that right or no?
It's actually the Commonwealth.
Oh, I'm sorry, you're right. Of course, it's the Commonwealth. Ms. Campbell.
Good morning. May it please the Court, Julianne Campbell on behalf of the Commonwealth. This is the Commonwealth's appeal, and I'm here today asking that this Court find that the conduct alleged in the application for complaint in this case establish probable cause for the offense of open and gross, lewd, and lascivious behavior. Specifically, if I may, I'd like to start my focus on the open element of the charge here, because I do think that that's what was challenged below. And
before you do, I think we need to establish some background facts.
Sure.
Specifically, our relevant universe, my understanding, this was a de Benedetto motion, so our relevant universe is the application for complaint, police report, or any other materials that were submitted with that to the clerk magistrate. Is that correct?
Correct.
The police report in this case indicates that the officer reviewed video footage.
Correct.
From the cameras in the house.
Correct.
Do we know whether that video footage was before the clerk magistrate or not?
I don't believe it was. But again, that's limited to my sort of review of the docket and the application packet for complaint. And I would suggest that within that application for complaint, I'd suggest there's a very extensive, detailed police report from which the clerk magistrate could have found and should have found and did find probable cause.
So you're telling us that your understanding is that the application for complaint and the police report were before the clerk magistrate, but not the video itself?
That, based on my review of the docket, yes.
That leads to this follow-up question. Do we know whether I will call her the victim, whether the woman who viewed the video footage viewed that footage as the acts in the house were occurring, or did she view it subsequently?
And I appreciate that question, Your Honor, because I think that the record is not clear on that, but what I will highlight for the Court is that the detective in his report documents that he was assigned on February 10th, and the complaining witness establishes when she's speaking to the detective, and this is in the narrative, that this occurred on February 9th. So
she also uses the present tense. I noticed that
correct,
as well in
correct.
the narrative. But we have no further information.
Not on this record, Your Honor.
Is that potential distinction important?
I would suggest it's not. And the reason I would suggest that is because it's an interesting, I acknowledge that there's no case that suggests that the action is not contemporaneous, right? And I acknowledge that I'm asking this Court to find a probable cause for an offense from which this Court has not found before. That being said, where the rationale behind this statute is to prohibit the open flouting of community standards with respect to sexual propriety or with respect to privacy, I would suggest that This case meets that. And perhaps in another case where there is a more or a more distant time connection, I would suggest that maybe that would speak to the elements of whether the shock and alarm experienced is reasonable.
What is it that you're saying satisfies the elements here that wouldn't satisfy the elements in a more attenuated case?
Sure. So I think specifically with respect to the last two elements of whether someone experienced shock and alarm and whether that a shock and alarm was reasonable, certainly I think the threat here, or the shock and alarm experience, I'll say, is very close in action and is in the midst of someone who is hired to work in the home and is scheduled to return.
Hired to work in the home is critical to this?
No, what I'm speaking as the facts of this case as a whole. So it's the fact that it's in this person's home, that the defendant is supposed to resume work in this home, that the defendant is on notice of these cameras and engages in this conduct anyway, and that it was discovered either, we don't know, but in deference to the defendant, let's say it was discovered after he left, I think it's still quite reasonable that one in that circumstance would experience shock and alarm, whereas if this was discovered, let's say, months later upon review of the security footage, and
You don't
there's...
think it would be shocking and alarming months later, whenever, to...
No,
turn on
but I
security
think
footage?
that would be an appropriate question for the jury to determine whether or not that's reasonable.
So it could go to the jury in either case.
I would suggest yes.
And a person is sitting at home, they have a computer, and inadvertently they click something on their computer, and full screen,
Sure.
they get live pornography, live.
Sure.
Sex acts of lurid description.
Sure.
Suddenly in their face. Is that covered by our statute?
I would suggest that does not violate the statute, and the reason is because of the first element, which requires that the intent be to cause shock and alarm, whereas I'd suggest that paid pornographers, the intent behind the creation of those materials is to provide, fulfill a desire from those...
The intent for this crime is intent to cause shock and alarm.
Yes.
It's not merely intentionally, openly, and grossly, for example, exposing yourself.
I don't believe so under the case law. That's not my understanding. My understanding is the intent is to expose and cause shock and alarm, and in fact did cause shock and alarm.
Do we have any cases where the perpetrator can't see the victim?
Well, I think some of the cases discuss, and it may be, I think some of the cases discuss, there's a case, I believe it's, and I can give the site to the court. There's a case where an individual, and I will give the site to the court, there's a case where an individual is in a van, and I believe he's caught or seen masturbating, and he's seen near a school. And what the case discusses is that it's the risk that someone walking by could see.
I thought you said there had to be an intent to cause shock and alarm. If it's merely a risk that someone might see him, he may well not have an intent.
Well, but the language for open is a reckless disregard of a substantial risk, and reckless implies a knowing...
Okay, so let's go back to the pornographer.
Sure.
Why isn't that done with reckless disregard for whether anyone will see this and be shocked and alarmed? A bunch of people are paying for it, but someone else might see it, and the pornographers might be saying, well, they should be really careful what they click, whatever. It's none of my business. I'm running a business here.
Again, my response to that is that would not meet it doesn't meet the intent behind producing. It is, the intent behind a paid pornographer is to earn an income, but also to fulfill a desire of people seeking out that information.
Some people might want to be shocked and alarmed by...
Sure, but I would
Right.
I would suggest to the court that if there is a pornographer who creates a video and mass distributes it to anyone and everyone that is on their email chain, potentially who didn't ask for it, potentially that could qualify.
Someone in California.
Well, I'm not prepared to speak to jurisdictional issues as to that, Your Honor. This occurred in Massachusetts. I'm asking this court to
Okay,
find.
so your theory covers emailing a recording.
Again, I think the question my response is that what cabins the sort of parade of horribles that my brother lays out in his brief are the other elements of the crime, whether the defendant intended the conduct and whether the recipient was reasonable in the shock and alarm that they view it. And that's what I think cabins the sort of parade of horribles that my brother references.
Can I interrupt for a moment and
yeah,
just
please.
focus on the open nature? So you agree, I think it's Adams, in which the defendant is driving in a car and masturbating, and the court says that's enough, right?
Yes.
Okay. And so here, the difference between what I would suggest is that we have a videotape.
Yes.
And so if someone rented an Airbnb, for example, and there are cameras all throughout the house, could they be charged if they engage in masturbation in the house? Could they be charged with open and gross lewdness?
So what I think distinguishes this case from Your Honor's hypothetical is that this defendant was specifically told about the cameras, and I'm not aware if this Airbnb tenant or renter is aware of the cameras, but
The big sign,
If-
everything that you do.
I would suggest that if a individual is staring into a camera that they know is recording them while masturbating, that yes, and if someone experienced shock and alarm, and it could be considered reasonable, that yes, that would
So
be,
people who rent an,
Open.
oh, I'm sorry, go ahead.
So
Yes.
If we focus on the element of the open nature of open and gross, right?
yes.
So, and we're not going to focus just
Yep.
for right now for a moment on the shock and alarm, because I think that isn't the issue here.
Yep.
At least, unless you prove me otherwise. So why is it?
Because the language from Kelly, which I recognize is an old case from the 80s, but the language in Kelly at
The
183...
80s aren't that old.
I meant in the scheme of case law,
They're
Your
getting
Honor.
pretty old.
In the scheme of case law, I try to rely on cases published since 2000, but, and I think cases since then do support that, but the language ties back to Kelly for this statute. And in Kelly at 183 to 184, and on page 185, this court defines open as recklessly disregarding a substantial risk of exposure to one or more persons. And by being aware that someone has a video camera running and masturbating openly in front of that camera without any effort to sort of hide one's conduct, I would suggest that yes, that does
People who
mean.
rent an Airbnb that has security cameras shouldn't have sex in the Airbnb they rented.
I would be concerned about cameras inside an Airbnb to begin with, but if there's a camera inside an area, yes, I think they should be concerned.
That they will be charged with a crime. A married couple rents an Airbnb because they're going to the
No.
vineyard for the weekend.
Honor,
And there are
just-
cameras in there, and
just
they
as-
have sex. It's not masturbation. They have sex, and it's visible on the camera. And they look at the camera while they're, I don't know how looking helps, but they look at the camera while having sex, and the homeowner is shocked because of his belief that sex is immoral and calls the police. You can prosecute that couple?
Your Honor, Justice Walsh's hypothetical was strictly speaking to the element of openness.
That's what I'm asking you. You think this is open?
I would suggest that if a couple is having sex and staring into a camera, that yes, that recklessly disregards a substantial risk of
So
exposure.
they better not look at the camera, but they can have sex in the apartment, even though they know the cameras are there?
Your Honor, being aware of the camera and looking at the camera, in my view, speaks to the other elements of intentionality. It does not speak to the issue of openness. It satisfies the issue of openness, but it would be, the Commonwealth would be hard-pressed to say that someone having sex on a vacation rental is done with the intent to expose themselves and to produce shock and alarm in another.
This is a different case here, though. I mean,
Yes.
according to the police report, the defendant pointed to the cameras and asked the woman, you know, what are those cameras there? She explained that she installed them and explained the purpose, and she said that she uses those cameras. So there's a different set of facts here, number one. And number two, can we infer from those facts that the defendant not only knew that the cameras were on, but did it with the intent to expose himself to this specific person for a specific purpose?
I would suggest that those are reasonable inferences to draw from the application complaint, especially when we consider that it's in the light most favorable to the Commonwealth, and we're talking about a probable cause standard.
So you have to intend a particular person to be shocked and alarmed before you can be prosecuted for this?
That is not what Kelly indicates. What Kelly indicates is a disregard of one or more persons. And if I may, with the minute that I have left, just to touch upon my brother's argument regarding the lack of notice, I would point this court's attention to Commonwealth v. Bundy, 465 Mass 538 at page 544. That's a 2013 case, and it is not this statute that's involved. The statute involved is posing a child or a live performance was the theory in that case, and that occurred during an Xbox Live video streaming indication. I'd also suggest that I'm not asking this court to imbue another element to this crime that did not previously exist, but rather to find that these facts as alleged satisfy the elements as they exist.
So you're asking us to hold that the word open includes not just doing something in someone's presence, but doing something through a camera, right?
In this case, I am, but I would suggest that's not a deviation
You
from
say
the...
that open is ambiguous on that point?
No, because the language in the case law is not ambiguous. It's a substantial disregard of exposure to one or more, and that's what I'm arguing occurred here.
Okay.
Seeing no further questions,
Thank you very much.
Thank you.
Excellent argument. Now we will hear from Mr. Chirokas.
Good morning, good morning, good morning. May it please the court, my name is Thomas Chirokas. I'm here on behalf of Russell Snow. And we're asking you today to affirm the district court's dismissal of this case. In my mind, Justice Nyman, you had asked whether it mattered whether this was live or whether it was recorded. It does not matter. In this case, it's clear and it's conceded that there was no person present in this home, that the person who allegedly viewed this at some point in time was at work. We can assume that's some distance away, however far. And this was not an open act by any stretch of the imagination.
So are you agreeing that, at least under the probable cause standard, looking at this in the light most favorable to the Commonwealth, we may infer that the woman was looking at the camera as the acts were occurring contemporaneously? Is that inferable from the record?
From the record, that is not inferable.
Tell me why.
Because from the record, you would have to speculate to make that leap that she saw it contemporaneously with when it had occurred. There was nothing to show from the record that she viewed it contemporaneously. As well, too, in a theoretical sense, there really cannot be a contemporaneous viewing when somebody is viewing something over video and over the internet. It appears to be live, like a television broadcast appears to be live. But from my knowledge of it, there's usually a delay. It has to go from the equipment that's recording it. It has to go through a router. It has to go through all of the various connections in the internet. It has to go back through another router into another computer.
Well, you've done a Zoom call.
I have.
And I understand it may not be literally instantaneous, but even what we're doing isn't literally instantaneous. It takes the time of the speed of light for what you're seeing of me to get to you, and my voice has to travel, maybe even through an electronic system, to you at the speed of sound, right?
Correct, but we're in the presence of each other, and that's the focus of this case, is the presence of each other. The focus is not the video, the focus is not the whether this is live or to go back to the 80s, Memorex.
Virtual presence.
Yeah, the Commonwealth is asking for a complete rewrite of the statute to include virtual presence.
Well, that begs two questions. And I was told there would be no physics, so let's move back to the facts of this case.
Okay.
I want you to assume the exact same facts in this case exist, but with one difference. Rather than masturbating in front of the cameras, the defendant does the same actions, but he is FaceTiming it to this same woman as it's happening.
Okay,
Would the Commonwealth have probable cause under that set of facts?
I would suggest no, because under the statute, in over 200 years of the case law with this statute, there has never been a case where presence was not required.
The word presence is not found in the statute, correct?
No, but Commonwealth
Is it
versus,
found in the case law?
yes, Commonwealth Quinn versus footnote 9. It's required
Can you read that case site again, please? Quinn,
439 Mass 494, to read footnote 9, to be open under General Law 272, Section 16, the conduct need not occur in public, but must occur in the presence of another person who can be alarmed or shocked. It cites Commonwealth versus Wardell, which I believe is an 1800 case.
So this is pre-virtual presence conceptually, correct? The Quinn case?
That's what the Commonwealth is seeking, to extend it to virtual presence.
What year is Quinn?
Quinn is 2003. Kelly is prior to Quinn. Kelly was an appeals court.
Does this violate any law? Do we have laws in Massachusetts about sexting or anything like that?
Not involving minors. The Bundy case, which my sister cited at the end, involved minors, involved conversations that were going back and forth. There is nothing that is...
Is it a crime while you're in someone's house to do something you're not authorized to do? Criminal trespass or something? I mean, you may not know the answer to that, but
Well,
I'm invited into the house to, paint. And instead, I snoop around in the medicine cabinet, I go down in the basement, I flip through private letters of the person, and they catch me.
Mm-hmm.
Have I committed a crime?
I think certainly if you're not allowed in the basement, then you have a trespass, but there would obviously have to be some sort of notice with the trespass statute that would qualify for that.
When a guest is invited in for a limited purpose, you don't think there's a possible criminal law violation if they utilize the premises for a different purpose?
No, I don't. I don't know of any law that would apply to that set of facts.
Can you go back to my hypothetical?
Certainly.
Your response was, that can't be a crime, or can't be this crime, because the defendant is not physically present.
Correct.
Okay. Have there been any cases,
Or not the defendant not physically present, but the
the so-called,
alleged victim being physically present?
have there been any cases that have discussed the concept of virtual presence, whether in this concept, in this crime or another crime?
I think the one cited by the Commonwealth was the Carter case. And the Carter case is distinguishable because you have two people who are interacting. They're interacting over a long period of time. It's clear that they have a relationship. And in that case, the court upheld for the first time that I was aware of, a presence that was with a person who was not...
Presence is
I
part
mean,
of
a
the crime?
virtual presence of...
I thought that was a murder or manslaughter.
It was a manslaughter,
Why is presence necessary for manslaughter?
because I think the case law on that was encouraging someone to, excuse me, to commit, to engage in a suicidal act.
Okay, that doesn't have the word presence in it.
It does not, but they found that it was applicable to that case because of the content of the text messages and the quantity of the text messages and the interaction and the affirmative encouragement by the defendant for this sadly young man to commit suicide. And I think we need to go to the statutory intent here as well, because the intent there was always to prevent an open imposition on an unsuspecting person who is present, who then encounters that. Now, if we follow through with the Commonwealth's theory here, this opens up a Pandora's box, and it's something that's better left pardon me, for the legislature. I don't think it's up to this court to effectively change the law. This is a legislative function here to rewrite the statute if there is a need to do so. Now, I'd also like to go to the second portion of my argument, which was, even if this is upheld, this is a completely novel interpretation of the statute. And it's essential for due process for someone to be on notice. Now, we go back to the example of somebody in an Airbnb. I mean, they would have no notice under the Commonwealth statute that they could be prosecuted if their actions are done on camera, even though perhaps they know the camera is there.
What about the Kelly case, which casts the standard as a known likelihood of observation by persons who would be affronted or alarmed?
In the Kelly case, it's distinguishable because there were people, pardon me, there were people present. There were people present right outside the house. There were people present, I believe, even on the first floor. And I think Kelly perhaps was dealing more so with the interpretation of what is public versus what is private. Whereas here, we have a question of what this is open and the presence of the people. In Kelly, there was nobody contested that those people were present. Here, we have the Commonwealth conceding nobody was present.
Well, their argument's virtual presence, though.
They're arguing a virtual presence, but however, that virtual presence, I think, first of all, it's question, as you brought up, when did this person see this? I mean, we don't know. But even still, it does not matter. It does not matter because nobody was physically present during the act. We have to give the statute its common, the words, the common meaning, the usual meaning. And here, presence.
Presence isn't the word in the statute, though, so I'm not sure that's your best interpretation. But
However, open is. Okay, and open has been interpreted to include presence. So now we're going even trying to a further interpretation. We're going far afield, and then we're going down that slippery slope.
Well, I mean, if I accept your interpretation, and we talk about hypotheticals, if somebody were in a park at midnight, there's nobody around, and the individual, soon to be a defendant, masturbates and broadcasts it live on a big screen so that everybody walking by on their way into the office is watching this. Weren't present.
You have first of all, you have a public park, number one. Second, they were not doing anything to try to conceal their, in a public park, anybody could walk right in at any point in time, okay?
So they're in the house, and they broadcast it and put it on a big screen so that everybody coming to the John Adams Courthouse today can watch them masturbate. And under your interpretation, because nobody was physically present, we all saw it and saw the big screen and couldn't avert our eyes. And we saw it even not simultaneously, but later. That's not open and gross?
That would be a disorderly conduct.
That's not open and gross?
I would suggest not, no.
Why?
Because the construction of the statute for over 200 years has required physical presence.
I also have to say, I mean, maybe I'm mistaken about this. Surely there are statutes prohibiting indecency in public other than open and gross lewdness. You can't just broadcast anything you want. If you put on a billboard something graphic in a place where children could see it, I don't think it would be open and gross lewdness, but that doesn't make it legal.
Well, in your example there, you have an individual who is actively broadcasting this, who's doing it, and that's his intent to do it, and that is what he is doing. He's engaging in broadcasting this. We don't have that here. We have an act that occurred.
Okay,
Your
but
argument is based on his presence. I mean, and so What I'm trying to suggest to you is that I'm not sure that we succeed just on that argument, because in the example that I gave you, with no one physically present while the act was occurring, I would suggest that at the probable cause stage, in the light most favorable to the Commonwealth, on the Jumbotron, it would be open and gross.
So if a person, going to another hypothetical, which was sort of raised earlier, if a pornographer had recorded that and somebody unintentionally puts that on a Jumbotron, could the pornographer then be prosecuted for open and gross? The person who, or the porn adult star, however you call them.
Disregarded a substantial risk of exposure to one or more persons of the public?
So then they recorded it. And then the question becomes, does that recording become a reckless act?
But you would agree, under Justice Walsh's hypothetical, it could be a public disorder offense under 272, Section 53, correct?
Which would be the disorderly conduct here.
Or
yeah.
disturbing the peace, or any number of common law crimes.
I mean, there is also, I mean, in theory too, if we look at what else could have happened here, okay? You have an alleged victim who's recording somebody, surveilling somebody without their knowledge, nude, partially clad, secretly watching that person in an empty house where they're not present, recording without his knowledge or without his consent. You have a violation by her of 272, Section 105. In theory here, I mean, if we're looking at other statutes. So I think here, though,
We have a dissemination of matter harmful to minors law,
yes.
right? Maybe that's the one. I don't think someone can cut a picture out from a pornographic magazine, put it on a billboard, and put it on Route 95. I assume that's not lawful. Now, maybe it's because it would amount to dissemination of matter harmful to minors. I mean, I don't know. We have obviously obscenity statutes, and I don't know, you know, given the narrow definition of obscenity, but and maybe I'm mistaken, but I would think there'd be laws against that. People don't do it. And even, you know, as you drive toward Rhode Island and people begin advertising so-called gentlemen's clubs, you don't see pictures of naked people on the billboards. I mean, I assume there's a reason you don't, but maybe I'm wrong.
I would assume there would be a reason as well, but I don't know the specific statutes on that. If there's no further questions, I thank you for your time. Thank you.
Thank you very much. Great arguments from both of you. It's an interesting and unusual case. We are going next to hear the case that was originally number 1 on the list. This is number 18-1717, Commonwealth versus Hughes. A little bit. And we will hear first from Attorney McCall.
Good morning, Your Honors. I apologize. My wife just had some serious surgery. I thought it was 9:30. My deepest apologies for being late. May it please the Court, James McCall for Darren Hughes. We are asking this Court to reverse his convictions and to reverse the order denying his motion to suppress. Your Honor, if I may begin with, a search conducted incident to an arrest may be made only for the purposes of seizing fruits, instrumentalities, contraband, and other evidence of the crime for which the arrest has been made, in order to prevent its destruction or concealment, in removing any weapons that the arrestee might use to resist arrest or effect his escape. Property seized as a result of a search in violation of the provisions of this paragraph shall not be admissible in evidence in criminal proceedings. That's 276, Section 1, Your Honor. After the controlled buy in this case of a very small amount of honey butane oil, the police seized a key card, a motel key card from the defendant. And I would suggest to the court that in no way, shape, or form could that be considered contraband or a fruit or
You have a
incident.
case that says the police feeling a hard thing can't take it out to look at it to make sure it's not a weapon?
No, they can take it out, but they can't seize it, Your Honor. You can seize, there's plenty of cases you can seize
Well, they can
keys.
take it out.
Yep.
We're in agreement, right?
Yep.
And in taking it out, they may see what it is, a key card to the Red Roof Inn.
Yes,
They can't use it for investigative purposes unless they have probable cause to believe that it's related to a crime. If they have probable cause to believe it's related to a crime, though, they can use it, right?
but I would suggest to the court that the police in this instance completely lacked any specific and articulable facts that would
Be
establish
reasonable
probable cause.
suspicion, but probable cause. So this gentleman offers, in a crude way, what seemed to be the services of a prostitute to the undercover police officer. And he goes on to say he has some girls nearby in a hotel, and that's what the evidence is on cross-examination, that's what he says. And then, as they're leaving the, whatever it is, mall or wherever they were, he also says, according to the testimony at least, and I'm staying across the street in the Red Roof Inn. Now, I don't know, I mean, of course, there's more than one hotel, but probable cause doesn't mean you're certain that this is the hotel these girls are in, and if you're the police, they're being trafficked if he's offering their services to someone. So why isn't there probable cause to believe that if they go to this hotel room, they're going to find a woman?
Because absolutely no nexus whatsoever, Your Honor. This is really a hunch.
I'm sorry, hotel nearby, and the one he's staying at is the Red Roof Inn, right across the street. I don't understand why you say no nexus. I guess we can argue about whether
Well,
it's
limited,
enough.
Your Honor, there's no comings and goings. I thought when I was thinking about this case last night, the officer could have called an audible and deferred arresting somebody for less than 1.5 gram of honey butane oil and conduct an investigation if he had a reasonable suspicion based on that crude comment. They could stake the hotel out. There could be comings and goings. There could be a sting. In this case, they seized a key card, which could never be used as a weapon,
They were allowed to look at it,
allowed to look at it. But then
and they are allowed to use it investigatively if they have probable cause. In addition, there's the question of inevitable discovery. So I'm not a police officer, but if someone said to me they had girls nearby in a hotel they were offering for prostitution, and I was a police officer, I might go look for them. And if he's being arrested and we know what hotel he's staying in, that's the first hotel I'd go to.
So then, Your Honor, if I may, we have the entrance, the issue of in essence, a warrantless entry into a hotel room. There is some sense from the evidence that the woman in there willingly spoke with the police officers, may have been invited in.
The judge made a finding that the police officers did not seek consent and that the police officers were invited in by the woman at the hotel room. So that seems to be a finding of fact. Are you arguing that it's clearly erroneous?
Well, I'm arguing that inviting someone in is not a consent to search, Your Honor.
I don't know what that means. Inviting someone in certainly is consent to allowing anything in plain view to be seen by the person who comes in.
If
I invite the police into my house, and foolishly I've left the stolen statue on the dining room table, and they see it.
for plain view, Your Honor, it has to be readily apparent to be
Well, there's a
contraband.
scale, right? And they've just arrested the person who this room is registered to for this resin of marijuana, whatever it is.
But again, I would
What's
say...
your strongest argument on appeal, would you suggest?
Well, I think...
Starting with the first issue, but
I mean, it sounds from the questions that this first one may not be, but I believe it is one of them. Secondly, Your Honor, we have the problems with picking the jury, with juror number 5 in particular. I think the record is crystal clear that juror number 5, during interrogation, offered that she was a victim of prior assaults, sexual assaults, including once by a black perpetrator, that she had ongoing symptoms as a result of those experiences, her belief that our court system has historically not been fair to women in cases of a sexual nature, in that quote-unquote victim blaming is the way society is set up. I think it's important to note that both the prosecution and the defendant challenged this juror for cause. And those factors, Your Honor, I would respectfully suggest to the court, made it impossible to conclude that juror number 5 could remain impartial throughout this trial, which involved a black defendant charged with trafficking a woman for sexual servitude, where the primary defense was to attack the credibility of the alleged victim.
How would you differentiate the statements made by this prospective juror, juror number 5, from the prospective juror in the Williams case you cite in your brief, 481 Mass 443? In that case, the juror made a statement to the effect of, "I believe the system is rigged against African Americans." And the judge found the juror not to be impartial and struck the juror for cause. And the Supreme Judicial Court said, not so fast. You still need to ask the juror whether or not they can be fair and impartial, see if they can decide the cases on the facts, because every juror comes, or I shouldn't say every, but many jurors come to the court with personal experiences because of their culture, their experience, whatever, what have you, and that does not automatically disqualify them. How is this juror here different than the juror in Williams?
I would suggest, Your Honor, because it's more specific as to a personal experience of a sexual assault by a black perpetrator.
Wait, was it a sexual assault or just an assault?
Assault.
Okay.
But there were the comments about the system being rigged against victims. So
And the judge made follow-up inquiry.
Absolutely.
Can you be fair and impartial? Yes. Will that impact you? No, et cetera. So isn't that ultimately a credibility determination to be made by the judge? How can we say it was clear error?
I know, Your Honor. I like to think, I've been trying cases for 40 years, and I would say that my experience is that judges bend over backwards to ensure that defendants get a fair trial. In this case, the defense lawyer was not asking this judge to bend over backwards, just to listen to that the Commonwealth and the defense both agreed that these specific factors for this specific juror in this specific case, that she should be challenged for cause. And the defendant ended up using, I think it was her last challenge, which brings us to the juror 72, which may not be as strong an argument as juror number 5, but the fact remains is that there was no challenge at that point in time. Juror number 72 stated yes to the question that she believed that if the police arrested a defendant, the defendant was more likely than not to be guilty. Now, there's rehabilitative questions and proper inquiry by the court, but the defense didn't have that last challenge.
Are you familiar with the Bateman case, which is 492 Mass 404?
I'd have to remind me, Your Honor.
It came out in July, so, okay.
Your Honor, with respect to, I just want to say in respect to the issue relative to whether the Commonwealth proved the drug case. Commonwealth v. Vasquez, 456 Mass 350, states, in a case charging a narcotics offense, the Commonwealth must prove beyond a reasonable doubt, quote, that a substance is a particular drug because such proof is an element of the crime charged. We know that the Commonwealth must prove each and every element of crimes beyond a reasonable doubt. Commonwealth cannot meet its burden of proving the trafficking in distribution or possession of cocaine without proof that the substance at issue is beyond a reasonable doubt cocaine. In this case, we have honey butane oil.
Okay, that doesn't exist, right? That's just a made-up name for something. So I don't really understand what it is. We don't have a criminal code that says it is illegal to possess honey butane oil, which, of course, right? Of course. We do have a law that says the resin of marijuana may not be possessed. That's the crime, right?
It is, but I think in order to prove that something is a Class D substance,
But if you proved it was honey butane oil, you wouldn't have proved it was a Class D substance, because honey butane oil isn't in the statute.
believe
There
me,
was a chemist who came in and testified that it was resin of marijuana.
resin of marijuana, yes.
In the indictment, it was charged as a
Class D.
substance, to wit, any mixture of marijuana.
Yeah, I
correct?
thought it was amended at one point
Yeah, that was amended during trial. I
during,
don't
during,
remember
during,
which,
during, during the trial.
but it was amended during trial, you know, to conform to the evidence that it was resin of marijuana, I guess, right?
And lastly, Your Honor, without waiving any issues, I think Commonwealth v. Fan, I think the judge's instructions on human trafficking omitted that the Commonwealth must prove beyond a reasonable doubt that there was a victim, in other words, someone whom the defendant enabled or caused to engage in commercial sexual activity. To be found guilty of human trafficking, a defendant must enable or cause another person to engage in commercial sexual activity. Court did not instruct on that. Granted, there was evidence of it, but again, the woman's testimony was challenged, her credibility was challenged, that she had testified under oath on prior occasions that it was simply a massage or a back rub or something like that. So I think that the omission of that part of the jury instruction is reversible error. And without waiving any arguments in the brief, thank you for your attention. And again, I apologize for being late.
Thank you very much, and we know you entered the case late, and we appreciate your thorough briefing.
Thank you very much, Your Honor.
We will hear now from Attorney Russell.
Thank you, Your Honors. Good morning, and may it please the court. Assistant District Attorney Lindsay Russell on behalf of the Commonwealth. Turning first briefly to the motion to suppress issue, I believe Your Honors picked up on the fact that I would like to highlight, which is the fact that by the time that the card was used in an investigative means, everyone was on the same page that there was at least a reasonable suspicion, if not probable cause, that there was prostitution occurring at the Red Roof Inn across the street.
Doesn't there have to be probable cause under Blumere's for it to be used for investigative purposes?
Yes, and there was.
Okay. I mean, you began by saying reasonable suspicion, and that seems clear, but...
I use that language because that is the language that the judge used in the motion to suppress finding, but I do agree that there was probable cause here, and I think that based on the record, there was probable cause to use it. There's definitely more than just a mere hunch, as my brother suggests, based strictly on the admissions made by the defendant. When it comes to, Justice Nyman, also the finding of fact when it comes to the fact that she invited them into the room. I think that that's a fair view of the record, that she consented, she had actual authority to consent, and in that case, that's dispositive. And I would just note that the police did not go there to search the room. They went there specifically to check on the well-being of any women that might be within the room, and that is why nobody thought about, can we get a warrant here? Should we get a warrant? The purpose of their going to the Red Roof Inn was to check on the well-being of the likely women that were there. When it comes to the issues involving the jurors,
This seems like the toughest one to me.
well, I would highlight that the standard of review here is very deferential to the trial judge, in that the determination that a juror is impartial will not be overturned on appeal in the absence of a clear showing of abuse of discretion or that the finding was clearly erroneous.
But, I mean, I don't know, maybe this is just the kind of thing we just have to figure out what's enough and what's not enough. You know what I mean? I don't know if there's much to say. Even the judge says, I wouldn't let this juror sit if there were any violence involved. And then the victim testifies that she was held against her will in this hotel room. I understand that's not, she doesn't testify that someone hit her to keep her there, but that seems like, right, forcing someone, presumably under some threat or other, to stay someplace while they're being marketed for prostitution seems pretty close to a violent crime to me.
I think the distinction here, though, is this theory of the case that the prostitution charges were tried on was not a theory of non-consent. JR never testified, it was consensual.
I understand that, but I'm just saying, if this person with PTSD from her own assault and so on really can't be, according to the judge at least, impartial in a violence case, mightn't her sympathy for this victim? I mean, that's the problem, right? An impartial juror would, of course, be able to slice it just like you said.
Right.
Like, well, there's a terrible thing she says happened, but that's not what the case is about. But that's what worries me about this. And I don't know how to tell whether something
Right. I think if your
rises.
honors look at the exchange that happened between juror number 5 and the parties, and then the 2 follow-ups that the court had with her, I think it's clear that she brings up and says, I think I'm okay on this case because this is not like my own.
Okay.
And the judge does agree with that and then subsequently finds her impartial and fair, and reiterates that. And she, again, the juror reiterates that nothing would affect her ability to listen and be fair and impartial in this case. And again, the court endorsed that.
Let me ask you about Juror 72. I guess in the case of Juror 72, so the failure to use the peremptory would have to be reviewed, right? We'd be reviewing the seating of number 5 and where the peremptory had to be used and whether that was right or not.
Right.
But Juror 72 is challenged, and I guess that's an abuse of discretion if she should have been eliminated for cause and wasn't.
Yes.
Okay.
If juror 72 should have been eliminated for cause, then that's when we can get to basically the peremptory issue.
Okay. So Juror 72 says that she believes that when the police arrest someone, she believes by a preponderance of the evidence that they are guilty, right? She says it's more likely than not. She doesn't say it's likely they're guilty or more likely that someone arrested is guilty than someone not. She says it's more likely than not.
Well, the question is asked in that manner.
Well,
The
and she
question is
answers- and
asked.
she says yes.
It says possibly, I'd say.
She said, right.
And I think
The
next
exact.
she's, yeah, go ahead.
Just to get to the record, to the exact language here, the defense counsel asked, which is a question that she's asked to other jurors, do you believe that if the police have arrested a person, then he is more likely than not guilty of the crime he's arrested for?
Yeah.
The juror responds, possibly, I'd say yes. The defense
And
counsel
what's the
says.
next question?
The defense counsel says yes. Juror number 2 says, 72 says yes. Then the court.
So yes.
Then the court follows up. There's a couple more questions by
Oh,
defense.
okay, but let's just start with that. I know the court then follows up and says, but could you follow instructions that told you not to do that?
Right.
But I think if I were a criminal defendant, I wouldn't want someone who came in thinking I was more probably than not guilty. They were already at a preponderance, and now an instruction is supposed to tell them, don't think what you already think, right?
Don't think about the white
You
elephant.
don't want that person on your jury, right?
I could understand why they might not want that person on the jury, but that doesn't mean that this person should be stricken for cause, especially when they come back to the question.
The reason you wouldn't want them on your jury is because they're not impartial, because they're not starting at 0. They're starting at already preponderance.
Well, not to criticize on either side prosecutors or defense attorneys in the way in which that they perform voir dire, but I think that, of course, the defendant is entitled to, and the prosecutors and both sides want impartial jurors, but if you think that somebody is maybe going to lean one way or the other, maybe even just based on appearance or certain inflections in the way that they answer, you might think, therefore, they might be more on your side than the other. That doesn't necessarily mean that on this objective basis that they're more or less impartial.
You said it aloud.
But you do need to get to the follow-up question, because I do think it's a reasonable question to ask somebody. If the police just arrested somebody.
I'm trying to figure out why. I mean, look, judges want to seat jurors. There aren't enough of them, right? I mean, I at least see this all the time. I think we do all the time. Sort of rehabilitation efforts by judges. But do you think you could be fair and impartial? And depending on what they've said, that's certainly good enough. But here she has said, I believe.
Possibly. She says possibly.
And then she says yes in the follow-up.
And she says yes, yeah.
I mean,
Judge has to make a credibility, I'm sorry.
Right.
The judge has to make a credibility determination. This case to me represents sort of an offshoot of the Williams case.
Right.
Which I'm still struggling to fully understand. I think trial judges have a little bit of difficulty with it.
Right.
But Williams essentially says when someone comes to court with a potential bias or viewpoint, the judge is sort of obligated to go beyond and continue to ask questions to ferret out those who are truly biased versus those who are not.
Right.
And there's a case, are you familiar with the Bateman case, 492 Mass 404?
I do know that that case came out recently that has to do with impartiality and juror selection, but.
It's actually strikingly similar to this case. There the judge asked, or there was a question during voir dire, do you believe that African-American males are more likely to commit crimes than individuals from other racial or ethnic backgrounds? The prospective juror initially answered, yes, I believe they probably are. And then there was a lot of follow-up questioning, and ultimately the judge determined the juror to be impartial, and the juror sat on the case. And my reading of the SJC case is that they held that this was a credibility call by the judge, and the record supported that.
And there was no abuse of discretion. So that seems like
I don't know if the same result would have held
Right.
Williams.
Right. That seems like an extreme case.
Yes, I would have struck that juror. But I can't disagree with the SJC
Right.
saying it's not an abuse of discretion not to. Of course, that juror said, more likely, is this defendant more likely than not guilty, which is the question that was asked.
I would also, just before that question, and I do think it's relevant, the defense counsel asked if you were to hear testimony from witnesses that were in direct conflict, a police officer and a civilian, would you give more weight to the other? He says, I don't think so. It would depend on what they're saying. And she says, well, without knowing, the content, would you have a bias toward one or the other, tend to believe one or the over the other? And she said, no. And then again, when it comes to the follow-up, and then the judge also comments on the record. She goes, I think sometimes people have initial reactions, maybe knee-jerk reactions to questions. And I do think it is reasonable to say, do you think that somebody was just arrested here by a police officer? And in this case, the only arrest that the juror, I think it's also important to highlight that the only arrest that they heard about was the arrest for an undercover buy that dozens of police were in the presence of. They didn't hear about any arrest as it related to the human trafficking charge. And I think that is an important consideration as well as far as this question relates to the facts of the case that they did ultimately hear. Unless there are more questions about the juror issue, with respect to the drug issue, the evidence did establish beyond a reasonable doubt that the defendant distributed and possessed with the intent to distribute a Class D substance, to wit, one that contained a compound, material, or mixture of marijuana. Now, obviously, we look at this in the light most favorable to the Commonwealth, and the only evidence presented was that this substance, whether it be called honey butane oil, the resin of marijuana, oil, that was a Class D substance. And more specifically, as the chemist testified who analyzed these substances, that it was the resin of marijuana. Now, the defendant never disputed at trial that the substance was anything other than a Class D substance, and the jury never heard that it was anything other than a Class D substance. Again, that the substance was referred to by some, including the defendant, Sergeant McManus, the undercover officer, as this basically street name, does not undermine the chemist's testimony in that the substance was a compound.
How was the indictment amended?
So the indictment was amended.
By taking out the to wit honey butane oil or something? Or?
Yes, and, well, originally the indictment said to wit marijuana or a mixture of marijuana.
Any mixture containing marijuana.
Any mixture containing
Sounds
marijuana.
like the right
And
thing
it
for it
probably,
to say.
admittedly, it would have been fine to stay that way, I would say. During trial, because a lot of the testimony that came out was this honey butane oil, there was a motion to change it to take out the marijuana and say honey butane oil. The parties seemed to believe it was just a ministerial change to conform with the evidence. They kept the Class D substance. However, I noticed on day 4, if I have it in front of me, the indictment was changed. I don't know if the clerk made some sort of error, but the judge says the way that the clerk has fashioned the indictments as of now, it just says there's no to wit. It just says a Class D substance. So it doesn't say honey butane, although it was amended to change to honey butane oil, it doesn't seem like that actually ended up on the indictment. And then the other point here is just the indictment didn't actually go back with the jurors. And the way that it was read in the charge, honey butane oil was not mentioned.
What I really care about is how the jury was instructed.
Right.
Were they instructed regarding that marijuana is a Class D substance?
Yes, the exact instruction was, I will instruct you as a matter of law that a Class D substance includes marijuana as well as any material, compound, mixture, or preparation which contains any quantity of marijuana. You must determine whether or not the material in question is in fact a Class D controlled substance. Any mixture that includes a controlled substance will suffice.
Any objection to that instruction?
No, there was no objection, and actually I would also note that defense counsel actually asked that honey butane oil not be mentioned in the jury charge.
So you only have a tiny amount of time left. I don't understand this financial, I know it wasn't objected to, but this financial situation instruction, what does that have to do with anything? I don't understand.
I did find that language in an old jury instruction, so I think that's what, it's clear she was reading verbatim from something. And there is case law to suggest that is a factor that jurors can take into an analysis and have
Take into account someone's financial situation and figuring out if they're a drug dealer?
financial resources, I believe, that's the...
How?
I do think that it can go either direction. In this case, there was no evidence concerning what the defendant's job was. However, in a situation where, say the defendant is an investment banker, and that came into evidence, well, why would he be a drug dealer if he's an investment banker?
You don't think investment bankers are drug dealers?
No, exactly, but the reasonable inference,
There are some.
but defense attorneys could use that as evidence to say he doesn't need the financial resources that come from being a drug dealer if he already has it. So I just think that instruction could go either way, and in this case,
Give that to burglars? He wouldn't need to burgle, he's already got a Mercedes.
I think that they can make that at least. But it doesn't seem to be used anymore, although I can't find any case law that suggests that was prejudicial. And here, again, there was no evidence that came in about any of his financial resources.
Okay. Your time has expired. Excellent argument by both of you. Thank you very much.
Thank
very,
you.
very helpful to us. Case is submitted. Great job. The next matter we will hear is number 22-506, Commonwealth versus Mulcahy. we will hear first. We're ready. Are you all set? From Mr. Us.
Good morning, Justice Rubin. May it please the court. My name is Attorney Adam Oos. It's my privilege to represent Richard Mulcahy. Mr. Mulcahy asked this court to reverse his convictions for armed robbery and involuntary manslaughter because the evidence of armed robbery was insufficient as a matter of law, and because the prosecutor's course of conduct during trial denied him his right to a fair trial and due process. Armed robbery is a specific intent crime that requires the Commonwealth to prove, beyond a reasonable doubt, that the defendant, while armed with a dangerous weapon, took the property of another against their will by using force or threats, and again, with the specific intent to rob. In this case, there was no intent to steal. Necessarily, obviously, it is well settled that we can't look into a person's mind to know exactly what they are thinking, so we must look to external circumstances.
Well, let's look at the internal circumstances. Let's look at the evidence. So,
Where I was headed, yeah.
the light most favorable to the Commonwealth, the defendant and his girlfriend went to the home to purchase pills. They knew that the pills were $10 a pop. They said that they were short on money initially. When they showed up, I think there were 15 pills in the bag, and the defendant threw on the bed $25 cash and a $25 bag of marijuana. And I know I may get some of the details incorrect, but I think in the light most favorable to the Commonwealth, can't it be said that they took $200 worth of pills, let's say, in exchange for approximately $50?
Well,
and walked away initially with it?
there's at the risk of nitpicking, Justice Nyman, there was an original offer of $10 per pill. Then there was some back and forth text messages. There was one particular text message where they said where Mr. Mulcahy's girlfriend sent a text to either Mr. Hickey or Ms. Tubbs, his girlfriend, saying, "I'm trying to see how much my boyfriend is shy and how much he's willing to pay." She does make an offer of, I think, $9 per pill if they'll
We're
hold
drawing
them.
inferences in the light most favorable to the Commonwealth. It is clear they did not have an agreed-upon price when they entered the apartment.
That's correct.
And yet, an amount of money is eventually thrown down, and a bunch of pills wind up in the possession of the defendant, or the defendant's girlfriend. I don't know who physically had the pills at each moment. It seems like there's that the jury could draw an inference this wasn't enough, and other evidence that it wasn't enough might include the seller then grabbing the putative buyer, putting him in a headlock, and at some point the putative buyer says, "Give him the pills," which I guess his girlfriend does because the dead victim had them in his hand. So I'm not saying it's an inescapable inference, but mightn't there be the suggestion, give him the pills would help him to escape because he was being held in a headlock for having stolen them?
A couple points to that, Your Honor, working backward. I think the fact that it was not clear at trial who said, "Give me the pills, take the pills," something to that effect. There was although Mr. Mulcahy did say, I told my girlfriend, give him the, I think he said effing pills or something to that effect. I think that speaks to Mr. Mulcahy's, part of the intent to rob is the intent to permanently deprive somebody of property. And Mr. Mulcahy testified, had he asked, I would have given them back. And in fact, he did then give them back.
Reasonable inferences drawn in the light most favorable to the prosecution. And intent permanently to deprive, he only had to have that at some point. He may have changed his mind due to the violence that he needed to stop, right? But he may have had that intent.
2 points to that. If he did not have the intent at the time of the violence, that's not armed robbery. That intent has to be concurrent with the use of force.
Rogers says we don't slice robberies up like that. I mean, I understand
You're
why
right.
one might, logically, but Rogers says, you know, but he put the toothpaste back or abandoned it or whatever, and they say, sure, fine, but we're not going to slice this robbery up like that.
Rogers is distinguishable in that case, he didn't give the toothpaste back. There was evidence that he was dropping the toothpaste as he was fleeing.
He no longer had an intent permanently to deprive them.
But there's no evidence in Rogers that he intended to give it back either. He was dropping it.
Okay.
Right.
I mean,
And I take your point about but the other issue here is that in Rogers, there was evidence that this person was a professional shoplifter who went there with a specific intent to steal, I think it was toothpaste. In this case, this is the only case that I could find where Mr. Mulcahy went there with the intent to buy. There was some back and forth in the bedroom. We'll never know exactly what happened there. There's no evidence that Mr. Mulcahy engaged in objectively menacing conduct while he was there. There's no evidence of a prior plan.
the victim is dead, so we don't have his evidence.
And in fact, during, I think it was volume 3 of the transcripts, the Commonwealth says, there was a back and forth about an adjutant hearing. The adjutant was later withdrawn, but the Commonwealth says, we don't have anything to counter Mr. Mulcahy's story. Now, the jury doesn't hear that, but the Commonwealth does concede that this is Mr. Mulcahy's story, and there's nothing to counter it.
But out of Mr. Mulcahy's own mouth, right, when the investigators asked him what caused the whole altercation, tells them, I didn't have enough money, right?
That was his guess.
I didn't have as much as I told him I did. If you look in the light most favorable to the Commonwealth, combined with all the other evidence, you think that's enough?
No. First of all, Mr. Mulcahy also told the police when they said, I think it was about 14 minutes or 15 minutes into the interview, did you go over to you didn't go over there to rip this guy off, did you? Mr. Mulcahy said without hesitation, no, absolutely not. 4 no's and an absolutely not. And again, there is no other evidence here. The fact is, even during that scuffle, and again, the Commonwealth stipulated that Mr. Hickey was the first to initiate contact. Mr. Mulcahy testified that he, in that instant, only assumed that he was being attacked. There's no evidence that Mr. Hickey was grabbing for the pills. There's no evidence that he was saying, give me those back. He just attacked Mr. Mulcahy.
I have to believe the defendant.
Because there's a burden of proof here that needs to be crested. And
I'm not sure why give the pills back to try to get him to stop the headlock isn't something. And I'll add it to what Justice Walsh has suggested about not having enough money. Somehow he has the pills, but he didn't have enough money. That sounds a lot like maybe he's taking them without paying enough for them.
But we don't know that he had enough money. I mean, how much is enough? A peppercorn? And I asked it rhetorically, but...
It's whatever the seller wants, I would think.
But we don't know what the seller...
I haven't engaged in any drug deals, but in ordinary commercial transactions, the seller says it's $8, and if you got the $8, you can buy it.
Well, that's right, an ordinary transaction, but this is, we'll call it gray market, right? It was a...
I think black, but go ahead.
All right. I want to just, So, there's no price tag on the label. He didn't walk in and say, I'll take, this bag of pills for $8 a pill. Mr. Mulcahy testified that in bulk, the pills could be anywhere between, $3 and $4. Plus, he had what he testified to, $75 worth of, I think it was sour diesel weed. But more importantly, the police didn't test these pills. We don't know what they really were. The police didn't even check Ms. Tubbs's pill bottle to find out how many were missing, if any at all.
Does it matter what they were? He wanted to buy them. He wanted to sell them.
Because that speaks directly to value, Your Honor. speaks directly to value. And we can't sit here and say it wasn't enough if we don't know what enough was. You know, Assad helps with this. Commonwealth v. Assad. I don't have the number in front of me. It's in my brief. But in that case, a man walked into his apartment, found two men in the apartment, who then pepper sprayed him and ran out. And they argued on appeal, that the defendant argued on appeal, I was just trying to escape the apartment. I didn't have the intent to rob. And the court there said, well, there was the intent to rob because a jury could find that you had broken into that apartment to steal something. That's not what happened here. Mr. Mulcahy was invited into that apartment for the purposes of a sale. He was then attacked. The Commonwealth has not proven that Mr. Mulcahy was trying to escape a robbery and used force to escape the robbery versus trying to escape from being attacked. And when we have two opposing but equal propositions, neither is said to have been proved. Now, I've got a few minutes here. I want to touch on the Commonwealth's, if there's no further questions about that, all right. Commonwealth's misconduct during trial. The trial prosecutor made various errors, beginning with how he introduced himself to the jury in questions that were designed to degrade or belittle Mr. Mulcahy during cross-examination, and he exceeded the scope of proper closing argument, particularly by comparing an autopsy photo of Mr. Hickey to a booking photo of Mr. Mulcahy, and finally by closing argument with an improper statement of personal opinion. All of these taken together.
Would you have made the same argument if the prosecutor just held up the autopsy photo in closing and didn't do the comparison?
Well, it depends what he said when he held up that autopsy photo, but I think that does speak to the point, is that we are aggrieved here by this comparison, and it's very much like the comparison in Fahey, where it was the booking photo compared to I think in that case it was the victim sort of shining, curated.
The evidence came.
Go ahead.
Sorry. The evidence came in, right? The picture, the booking photo, and the autopsy photo. And the Commonwealth had to prove, since self-defense was raised at trial, that the defendant used excessive force. So if you've got a picture that's already into evidence and you're trying to determine, was the force reasonable? And you look and you go, look at what he looks like. Take a look at what he looks like when you go back to the jury to determine whether excessive force was used. Why is that error?
Because the point of self-defense, Your Honor, I think is to try to escape unscathed if possible, but the point here is that it's not...
But it's not self-defense if you use more than what is reasonably necessary to escape. So the comparison of this person has got barely a nick on him, and this person has got stab wounds and blood and all the rest, that seems to the jury maybe it's excessive.
Well, 2 points. First, the evidence shows that the injuries that Mr. Mulcahy was sustaining or was about to sustain, according to his testimony at least, is that he was being strangled, that he was being choked. Those injuries are not necessarily going to be visible to the jury. And then there's the issue of purpose versus meaning. Holding up the photo, here are the injuries. Is this kind of action, asking the jury whether this kind of wound or this kind of, this version of self-defense is reasonable is one thing. But he held it up for shock value, I think. If you look at the context, what is the meaning of him holding this up? This is how Mr. Mulcahy looked. Here's the other guy. He's trying to create some outrage for the victim. That's improper.
Defense counsel's the one who sought to have the booking photo admitted as evidence, correct?
I don't remember that specifically, but I think it can, at the very least, I don't think he objected to it. I think, yeah, I don't remember.
I think defense counsel actually moved to have it admitted in the defense case. That's my recollection.
It might be, but that doesn't necessarily mean that the prosecution's allowed to hold these two up and compare the two for shock value.
Did defense counsel object to that move by the prosecutor in closing?
No, and I've got a few seconds here left, but I will note that the lack of an objection and even the lack of specific curative instructions are not dispositive. And where there is a lack of forceful instruction, Commonwealth Fahey in Note 10 tells this court that where the risk of prejudice is high, this court has a duty to look at the curative instructions with skepticism.
But we're at substantial risk of a miscarriage of justice if it's not objected to, right? Your burden is higher.
That's correct. It is a substantial risk burden, yeah.
All right, thank you very much. Excellent argument.
Thank you.
We will hear now from Attorney Gautier.
Good morning, Your Honors. Excuse me, Stacey Gauthier for the Commonwealth. The Commonwealth presented sufficient evidence that the defendant committed an armed robbery. In addition, there was no errors that were committed by the prosecutor that should require reversal in this case. Therefore, it's the Commonwealth's position that the defendant's convictions in this matter should be affirmed. I will start with the sufficiency issue first. In order to prove an armed robbery, the Commonwealth has to prove the 4 elements: that the defendant was armed with a dangerous weapon, that he applied force or violence to the victim, or by words or gestures put the victim in fear, took the property of the victim, and did so with the intent to steal. The defendant takes issue with the sufficiency on 2 of the elements. That would be the applying of force as well as the intent to steal. And with regard to the defendant's intent to steal, we have evidence here that the defendant went to a drug dealer armed with a knife, with too little money, without having made an agreement as to how much or how many pills or how much. He threw down the money that he wanted to pay, and when he attempted to leave, he then struggled with Mr. Hickey when Mr. Hickey attempted to take back possession of his pills, or his girlfriend's pills. We also have the texts that led up to the incident, where Ms. Delory, I believe, admitted that they were, quote, shy, short of some money. She also, or whoever was texting from her phone, stated, I know we wanted 90, but now would you take, can we do 45? And then she said she didn't have as much cash as before. And then they were offering to pay more money if the defendant would, if the victim would hold them for them. And she had stated, me and my boyfriend really need these things. We also have the defendant's statement at the interview. When asked what started the altercation, the defendant told the police, well, the fact that I don't have enough money, I didn't have as much as I said I had. And then also, he also told the police during his recorded interview, we knew that they only wanted to sell in bulk. And clearly, he didn't have enough money for bulk, hence he left $25 and some weed and left the apartment. So I would suggest that, in the light most favorable to the Commonwealth, would be sufficient evidence that he intended to steal the pills. And with regard to taking the pills by force, under Rogers, as has already been pointed out, the force necessary for a robbery may be used either to accomplish the taking of the property or to effect the escape. And in the Rogers case, that was the CVS larceny, stealing, shoplifting case, the stabbing occurred after the defendant had dropped the toothpaste, and again, the court had stated that was enough. That was considered force. In addition, I also, in my brief, had cited Commonwealth versus Haddock, which stated that a victim can use reasonable force to regain his momentarily interrupted possession by the use of reasonable force, short of having to employ a dangerous weapon. And here, Mr. Hickey did not use a dangerous weapon. And then also the defendant's statements to the police. He told the police in his interview that he was pulling down the stairs and that the two were fighting, on the stairs, and that there was a scuffle on the porch. So I would suggest that was sufficient force, and I would suggest that the Commonwealth met its burden as far as sufficiency of the evidence of the armed robbery. Thank you. And then I'll move on to the closing argument, the photograph issue that my brother had raised.
Before you get to the photograph,
Sure.
I have a question for you
Yes.
about the way the district attorney introduced himself. Look, I'm not saying this prejudiced the jury venire perhaps it's not prejudicial at all, but what is the purpose of introducing himself as, I work for the elected district attorney for the Bristol district? How is that relevant to anything?
I mean, I would suggest he was invited by the judge to introduce himself to the venari, and he did. Why he said elected, I don't know, but I would suggest that,
What does it add? It certainly could detract in the future from a Commonwealth case. What does it add?
I don't know that it added anything. It tells the venari who the district attorney is, that he's
Why
elected.
is it important that obviously it was important to the prosecutor to let the jury know? He said it twice. And usually what prosecutors say, because they're smart, is designed to get a conviction. I mean, I don't know. I've never seen it before, and it seems a little odd to me, at least.
Well, there was no objection to it.
I understand that. I'm just saying maybe people should think about, where risks lie.
But, again, there was no objection, and it was not said during the closing. It was said, when they were still picking the jury, which was days before they had made their verdict. And I would suggest that it was not prejudicial to the defendant.
So getting to those photos.
Thank you, Your Honor. So I would suggest that, first off, I would say it's not entirely clear exactly which photos he showed. During the closing, he doesn't hold up any photos and say, oh, I'm showing you Exhibit 15 and I'm showing you Exhibit 12. So it's not even entirely clear which photos he showed. And I know my brother had stated that it was autopsy photos, and that's how I argued my brief. But then in preparing the case for argument, one of my coworkers had noticed that the last line he stated was fatal wounds to his right thigh, blood-soaked clothing. That's on transcript 11, page 38. So it's not even clear that it was an autopsy photo. He wouldn't have been, I would suggest he would not have been wearing clothing in an autopsy photo. But even still, it was our duty to disprove self-defense, and I would suggest that that's what he was doing at that point. The judge specifically instructed the jury to not allow their verdict to be swayed by any sympathy. He also instructed that emotion, sympathy, passion, and prejudice have no place in their deliberations. He instructed that closing arguments aren't evidence. And after the autopsy photos were showed to the jury, he made a finding. He actually made the finding at the close of all the evidence. I apologize. He had not seen any emotional reaction from the jurors after he showed the photos. And that was on transcript 12 on page 12. And it's presumed that the jury followed the judge's instructions. In addition, there was no objection. So we're looking at a substantial risk analysis. And I would suggest also that it was apparent that the jury wasn't swayed by any emotion or sympathy because the defendant was on trial for first-degree murder, and ultimately the jury only convicted him of involuntary manslaughter, which was the lowest of all the lesser-included offenses. And I would suggest that also indicates that they weren't improperly swayed by emotion from looking at photographs. And I would also suggest that I believe it was the Fahey case that my brother cited to. That case stated that the prosecutor had showed like a really awful picture of the defendant and like a really nice picture of the victim. And here, I mean, it was a booking photo. You can see the booking photos. He didn't look, I would suggest, too bad. He had some cuts and scrapes on him, which actually went to his argument that he was in a fight with Mr. Hickey. And certainly an autopsy photo wasn't a very attractive photo. But again, the judge instructed the jury. And if the court has no further questions on any other issues.
Seeing none, thank you very much.
Thank you. I'll rest on my brief.
Excellent arguments by both of you. The case is submitted. We are going to take our traditional mid-morning break. And then we will return in 10 to 15 minutes to hear the remaining 3 cases that are on for today.
Thank you.
All right.
Thanks, nice to meet you.
Finally.
Did you go to law school with Steve Nato? With who? Steve Nato.
Good morning. We will continue with our next case, which is Department of Children and Families and Another versus Mother and Another. As all of the attorneys I'm sure are aware, this is an impounded case. We don't use the names of any of the parties or related persons. You can use whatever, mother, child, and so on. Instead, we will hear first from, Attorney Penta.
I don't look like Attorney Penta, Your Honor. Michelle Moucherit, good morning, Your Honors. Michelle Moucherit on behalf of the appellant's mother. I did not...
What has happened?
I can explain to the court, Your Honor.
We can stop the clock, but I don't understand
Sure.
what's happened here.
So Attorney Penta prepared the brief, and he was preparing for the argument, Your Honor. However, he could not be here today. He requested a continuance. Rather than postponing the hearing, CPCS gave me permission for limited appearance, which is to do an oral argument, Your Honor. Hence, I'm here.
Okay, have you filed an appearance in the case?
Yes, I did, Your Honor.
Okay. We will, and tell me your name, because it's not on this list.
Michelle, double L,
Yeah?
Moucherit, Moucharit, as a Tom E.
Okay. We will hear from you now, Attorney Moucherit.
Good morning, Your Honors. Michelle Moucherit on behalf of the appellant mother. The issue that we have today is this case has not ended, Your Honor. In fact, the case is scheduled for review and redetermination next month,
I thought it was scheduled for July.
and it was continued.
Because of the appeal?
No, because the review and redetermination is statutory, Your Honor. It's every 6 months, so parties can continue for another 6 months. It didn't continue because of the appeal.
Do you know why it was continued?
My understanding is that the judge wanted a report on this issue for the appeal, and also the mother has a new attorney in trial.
Okay. That sounds like it was continued because of the appeal.
The review,
If the,
I agree with the court, except that review and determination is statutory right.
I'm aware of that. So I don't understand why it would be continued because of the appeal, but if it was, it was. All right, so, go ahead.
Thank you, Your Honor. So basically, the background of this case, mother has 3 children. 2 children are with their father. The younger child, who's subject to this case, is right now in the permanent custody of DCF. The child is 4 years old. 51A was filed July 8, 2019, and DCF obtained the temporary custody shortly thereafter.
We're very familiar with the facts, so
Okay.
let me ask you a question.
Sure.
My understanding of your central argument is this. Essentially, you're arguing that we as a matter of law cannot accept this judge's conclusions of law because in her findings of fact, she failed to mention anything about the defendant's, or rather the mother's expert who testified at trial. Does that fairly summarize your argument?
That's one of the issues, Your Honor.
Okay. So here's my question with respect to that issue. The judge, in her decision here, ultimately decided not to terminate parental rights, made a finding that DCF did not make reasonable efforts, increased visitation, I believe, or awarded visitation, added sibling visitation, and also ordered, I think, there was an order for a possible evaluation of a reunification plan, at least from the judge's findings. So my ultimate question here is this. Based on all of that, is it a reasonable inference to draw that the judge did take the expert's opinion into consideration?
Your Honor, the judge paid close attention to the evidence, but for some reason, when we read the findings and the conclusions of law, and we read the transcript, there is a big part of the evidence that's missing in the findings and the conclusions. And the evidence that's missing is the experts. The expert witness is the only one who testified to the most ultimate issue, and that is the connection and nexus between mother's mental health and her ability to parent. For some reason, the judge did not, even to her findings and conclusions of law, did not indicate the DCF's concerns and its nexus to mother's ability to parent discharge.
Okay, so, no, go ahead, please.
So your answer, I think, is you're saying, no, we cannot draw the inference that the judge properly took it into consideration, even based on the judge's ultimate findings.
That would be my argument, Your Honor.
And what is the difference? There's going to be this redetermination hearing. So let's say we, and I don't want to cause further delay to a resolution of the case. Well, actually, let me ask you a couple of questions. Has DCF now been doing whatever the judge said was necessary for reasonable efforts since this judgment entered? It's a long time ago now.
So based on my conversation with the trial attorney, the new trial attorney, I understand that they have not increased visits.
They have not increased visits.
No, Your Honor. That's
Can
my
I-
understanding and the conversation I had with the trial attorney.
And can I just
Oh, sorry.
ask one other thing? And what difference will it make in the redetermination hearing? Let's say we remand this and say, oh, you didn't explain what you had in mind about this expert. Could you tell us? Now, of course, it's possible the judge would say, oh, yeah, I totally forgot about the expert, and I believe her, and now I'm saying no longer currently unfit, although currently is 2 years ago, so I don't know that that's of any relevance anyway. I'm just trying to figure out, and of course the judge might well say, oh, I didn't spell it out, but I didn't credit that, or I gave it little weight because, and have some reason. We don't know what she thought about it. How does that affect the redetermination hearing that is supposed to be held next month? Does it matter which is the baseline or not?
Your Honor, it does matter. A review and determination hearing is basically not a clean slate. The parties need to start to prove that the mother, or rather the mother at this point, needs to prove that there are substantial change of circumstances.
Of circumstances, factual circumstances, right?
That's correct, Your Honor.
All right, so the conclusions the judge reaches are not, right, the conclusions of, the ultimate conclusions, is she fit, is she unfit, that doesn't matter. What matters is there some change?
Your Honor, it matters. It matters because when we have a hearing that took place, and now we're looking at the standard for review and determination, if the findings, Your Honor, are built or, built on erroneous findings, Your Honor, then review and determination is invalid. So review and determination is only valid if the findings are not erroneous.
Findings from the prior hearing.
Correct.
A new hearing is held at review and redetermination, right?
That's
And
correct.
the burden remains on DCF to prove by clear and convincing evidence unfitness.
In review and determination, Your Honor?
Yes.
No, Your Honor.
What is the burden?
It's on the mother to show that,
As a threshold, a change of circumstance.
correct.
Okay. The child has also asked for this review and redetermination, right?
I think the child is the one who filed for review and determination.
Okay, so
in this
there's
case.
going to be a review and redetermination.
There will be a hearing, Your Honor, on review and determination. So the case is not ended yet.
And if we send this back, what does that do to the timetable of that?
Well, Your Honor, the department is going to have to prove beyond, by clear and convincing evidence that the mother is unfit. And to do that, they have to, again, weight the evidence. If I may, Your Honor, it is not up to us or this panel to determine what weight the judge has given to this expert witness. expert witness was
I understand.
qualified.
I'm just trying to figure out, so what are you asking us to do exactly?
I'm asking this panel to remand the case, vacate the order, the finding of unfitness, and remand it for a new trial, Your Honor.
For a new trial?
Yes, Your Honor.
Why couldn't we remand it just for new findings? Say, Judge, you did not take into account, or at least based on what we see, you did not mention the defense expert. Reweigh it, tell us in writing, make findings as to the credibility of the expert, and redo your findings. Why would we need a new trial?
So, Your Honor, remanding for the purpose of the court, the lower court, amending its finding is at the minimum. And the reason why I'm saying it's at the minimum, because enough time has gone, and the mother was deprived from having contact with the child, being more involved in the child's life. Let's not forget.
I don't.
Remand it for a new trial, you're talking about an even longer delay in a longer period.
Your Honor, if we're talking about a new trial, the department will retain the temporary custody of the child, not permanent.
Okay, but I'm trying to figure out okay, so let's say we agree with you and say, oh, vacated and a new trial, and the new trial takes 9 months or a year to be done, and then someone appeals, otherwise there are no findings, right? And the findings take time, and meanwhile the child and mother are separated, right? Now, I don't know exactly, and I'll ask your colleagues, what has happened that has prevented increased visitation, because I thought that was what was supposed to happen. I thought they were supposed to begin making reasonable efforts, and that, so far as the judge was concerned, this could have been headed toward reunification. If there are no more visits, I don't know how you can head toward reunification.
Well, Your Honor, a new trial will have a chance for the judge to assess the mother's fitness. In this case, Your Honor, by looking at the findings and conclusions of law and the transcript, the mother has done everything she's expected to do.
And how does that look compared? So then we don't do the redetermination because we don't have an initial determination. Is that right?
That's correct.
So you're asking us to put in place, just to start from a blank slate and do this again. And if we conclude that really all that's needed is an explanation of what happened, obviously she could say something that made us think like, well, that's insane, we have to undo that or whatever. But we send it back and we get something about this. Maybe it results in some changes, maybe it doesn't. But again, I'm not sure why we would have a new trial. You say a bunch of time has passed, but usually that's why there's redetermination.
So I just want to be clear. In trial, the focus should be current fitness.
Isn't that the focus in a redetermination hearing?
Redetermination, the focus is more of what changed since the last hearing, Your Honor. So the review and redetermination.
That she can no longer be found unfit, correct?
Correct, Your Honor.
Although she
Can I
did.
procedure
Please,
just
you have
ask,
questions.
at trial, were there proposed findings of facts and conclusions of law that were submitted on behalf of the mother?
Yes, Your Honor.
And in those proposed findings of fact, was there mention of the expert?
Yes, Your Honor.
And so my understanding is really what you're looking to do is vacate the judgment of unfitness. Not technically remand, it has to go back anyhow, but you're asking us to reverse the finding that mother is unfit due to the lack of any mention of a witness who testified on mother's behalf.
Partially, yes, Your Honor. So I'm asking for a new trial based on the fact that it doesn't seem that the court took into consideration the expert witness and also the weight of the evidence, Your Honor. So when we look at the findings, the mother was able to overcome her shortcomings, such as a therapy, such as domestic violence, Your Honor, such as even housing, DCF cannot terminate just because of poverty, Your
The
Honor.
judge didn't terminate, correct?
She didn't terminate.
So my question is, and it's related to Justice Nyman's earlier question, it does seem that the judge gave some consideration to your client's progress. And this expert, well, the judge may have credited or discredited, we don't know because it's missing from the opinion. The expert's testimony was really about parenting ability and the mental health trauma suffered. And you're suggesting that doesn't go toward reasonable accommodations, it goes toward the ultimate finding of unfitness. Do I understand that correctly?
Yes, Your Honor.
Thank you.
With respect to the redetermination hearing, do we know yet what DCF's position is?
Your Honor, I don't know what DCF's position, but I know I spoke with the trial's attorney, and my understanding is that the trial attorney filed for a redetermination. So I had a conversation with her just as recently as last Friday. There has not been any increase of visits. There hasn't been any movement from DCF. Yes, Your Honor.
Did anyone ask the trial judge for supplemental findings of fact?
No, Your Honor.
Why
And-
not?
Well, go ahead.
Again, the mother has a new attorney, trial attorney. So the previous attorney who handled trial is no longer handling this case.
When did that
I
happen?
couldn't ask.
When did that happen? When did the new trial attorney come in?
Came in, I believe, it came in 3 months ago.
Your belief, though, is that for this whole time, no more reasonable efforts have been made by DCF, even though they were ordered by the judge.
That's my understanding, Your Honor.
No one brought a contempt motion?
In care and protection, we don't see contempt as much, but the way we handle it, it's
Or a
more,
motion for reasonable efforts? Those
or
motions-
abuse of discretion. Reviewing the record, nobody brought any motion, Your Honor. And I think my time is about to be up, if there's no
Your time is
question.
up, but we may still have questions.
If there's no question, I would rest on my brief, Your Honor.
Okay, thank you very much.
Thank you.
We will hear next, I gather you all are splitting your time, and we will hear for 10 minutes from Attorney Duran.
Thank you, Your Honors. Good morning, and may it please the Court. Assistant Attorney General Angelica Duran on behalf of the Department. We ask that you affirm the Juvenile Court's decision finding mother unfit to assume parental responsibility and the child in need of care and protection. As a care and protection case, as counsel for mother mentioned, mother can seek redetermination and fully litigate parental fitness within 6 months.
She does have a threshold to show a change, right?
Your Honor, I'm not as familiar with the review and redetermination proceedings specifically, but in terms of this case, we're looking at the record of whether there was clear and convincing evidence that mother was unfit at the time of trial.
Okay, so we now have a judgment in which what appear to be detailed findings, when you read them, turn out to completely fail to even have one sentence saying, I didn't credit the expert because X. They don't even mention the expert. I was unaware there was an expert till I read I always start by reading the opinion below, and I read it and I thought, oh, this seems very reasonable. And then I heard there was an expert witness who's not mentioned. What should we do?
That's correct, Your Honor, that the expert witness isn't referred to in the findings, but that does not mean that it's reversible error, that the findings themselves are reversible error.
I understand that you hypothesize reasons she rejected them, but it looks like, I mean, we need to be able to see on the face of this clear attention to the evidence. There are only 3 witnesses and she doesn't mention one of them.
Well, she looks primarily at the testimony of mother herself and of the social worker, but we see an even-handed assessment of factors that were credited to mother.
What about the testimony of an expert who said she could parent the child? How was that even-handedly dealt with? I don't see it mentioned.
It's not mentioned, but we can infer from the lack of reference that the judge did not find that credible.
Or we could infer from the lack of mention that she totally forgot about it by the time she wrote her findings of fact months later. Or that she didn't care about it for some, right? I mean, I don't understand. We can't infer. We'd have no idea why it's not mentioned.
Is your position that if we are to extract what isn't there, right, and we look at all the other factors, that we affirm because basically we have evidence that we can accept of unfitness?
That's correct.
Regardless of whether she fell asleep, with all due respect, whether she honestly forgot, or whether she discredited and was trying to be kind about it and not mention that. Is your legal position that if we excise that mistake and we look at the rest of the scale, it supports the judge's finding of unfitness? And if that's your argument, do you have a case that says that?
That's absolutely my argument, Your Honor, that the findings themselves provide clear and convincing evidence. In terms of particular case, I did append a case to my brief, a Rule 23 decision in Retanya, that states that inferring the judge's endorsement of one expert opinion while not mentioning the other expert's opinion reflected his rejection of the latter and did not constitute abdication of the judge's obligation to wrestle with troublesome facts. And we see that the judge, in the conclusions of law, you can see in each assessment, part of it is a credit to Mother and her progress, weighed against her shortcomings. We see that Mother has continued to have a chaotic life and is unpredictable. She's refused to submit to a neuropsychological exam, and that's needed so the department can assess what services she might need, the diagnoses, and provide direction to put support in place for the child.
The judge was not supposed to be looking at future fitness, right? This is current unfitness. That's all that the judge ruled on.
Yeah, it's on current unfitness, but the judge looks at the history for prognostic value and also the risk of harm based on Mother's current behavior.
Okay, so she did not have a significant other at the time of trial?
Not that she testified to.
Not that the judge found?
Not that the judge found, Your Honor.
Okay. How can she be a risk of domestic violence in her relationship currently if she doesn't have a relationship?
Well, the judge looked at two things. One, that Mother testified that her approach would just be to not have any kind of romantic relationship in the future.
And she said that's unrealistic. But that's about the future, not about current fitness.
Well, the judge took that into consideration with the history, and so one of the findings made was that there was a domestic violence incident that occurred right after child was born, while child was present in a hotel room with Mother and Father.
No, I know all the domestic violence incidents, and the judge may well be right, that if she finds herself in another relationship, there will be domestic violence. But the question is she currently fit, isn't it?
The question is whether she's currently fit, but part of the assessment was Mother's judgment. And so when she failed to report that incident where child was present, and it didn't come out until trial itself, the judge looked at what that meant for the judgment, Mother's judgment in terms of her parenting, and whether in the future she would potentially disclose information. And so there was a risk of harm to the child that could be physical or emotional in the future.
Can you tell me what DCF's goal for this family is?
At the time of trial,
No, now.
I believe it's still reunification, Your Honor.
You think their goal is reunification, so you think that at the redetermination hearing in a month, DCF will be arguing for reunification?
I don't know, Your Honor. I can't make any representations as to the review and redetermination process.
Mother's counsel says the visits haven't been increased. but I read a paragraph here that says that DCF hasn't allowed increased parenting time, and given the quality of visits, parenting time increase is warranted, and that a plan of reunification was approved by the court. Do you agree that there have been no increase in visits since this was issued in 2022?
I am not aware of that, Your Honor. I can't
You're
speak
not
to
aware
that.
whether there have or haven't been increased visits?
No, Your Honor, I don't know. I would think that the department would comply with any orders for increased visitation, but I think we need to look at the record as it stood at the time of trial.
So, for purposes of this next question, please understand, we have not made up our minds on this case.
Not made up our minds.
Not at all. We never do, and certainly have not in this case. With that in mind, assume, for the sake of argument, that we agree with the appellant's argument. That is, we agree that on this record, we just cannot say whether or not the judge properly considered the expert's testimony. If that's the case, what is the appropriate remedy?
If the issue is the expert's testimony?
If we determine that the judge, we cannot tell from the record whether or not the judge properly considered the expert testimony, and we decide to reverse and we remand, what is the appropriate remedy on remand? Is it a new trial? Is it a remand for the judge to make new supplemental findings? What is the correct remedy?
I'm not sure, Your Honor. But again, I would stress that this has to do with, that there should be deference to the judge's findings, the judge's assessment, looking at all the factors, not in any one in isolation, and that the judge develop both in the findings and the conclusions of law the nexus between those various issues and the risk of harm to the child.
We understand that. The difficulty is perhaps there are no findings to defer to, at least in part of the record.
Again, I don't think that's, even if it's the case that it troubles you that there's no reference to the expert testimony, it's not reversible error in this instance. The point is whether mother was fit to assume parental responsibility. And at that time, both the judge and the department were looking at services that mother could benefit. The court credited the services that she had engaged with, and the hope is that mother can become fit in the future. That's why this was not a termination case.
Okay, your time has expired. I see no further questions. We will hear now from Attorney Taylor.
Thank you, Your Honors.
Good morning. Susan Taylor for the appellee child. May it please the court. As I listen to this, Your Honor, on behalf of the child, we would ask the court to affirm the judge's findings. First, with regard to...
You were an appellant.
Initially, yes.
And that was because a substituted judgment had been made that reunification was what the child wanted. I assume these are substituted judgment calls that are being made? That you're not asking a 3-year-old, right?
It was a substituted judgment.
Made by Attorney Hain?
It was.
Okay, and did Attorney Hain change her mind?
Yes.
So it's not a new lawyer, Attorney Hain herself?
Yes.
Yet she is no longer trial counsel for the child.
She is trial counsel.
She is trial counsel.
She is trial counsel for the child. Only mother's counsel has changed.
I see.
Repeatedly.
And when did this change occur?
Trial counsel filed the request for review and redetermination in February of 2023.
And so we know nothing about counsel's view of this between March of '22, when this issued, and February of '23, when apparently her substituted judgment for the child had changed?
Well, I would say that initially, at the time that the judgment issued in December of 2021,
Yes.
it was the substituted judgment that mother was fit and that the child should go home. Since that time, there has been there has been a change, and that's exactly the problem with an appeal that I would argue was never right to begin
Even
with.
though I'm not supposed to, I'm going to ask you what happened.
I know that. And so what occurred is in December of 2022, child was reunified with father for approximately a month. And then father...
How can she be reunified with father? Father conceded unfitness.
Well, but the department still has custody.
I agree with that.
It still has legal custody, and they have the right to place the child with the parent. So although father conceded his fitness in December, at the time of the trial,
Yeah.
they placed the child with father in December. Father overdosed, and child was removed again, put back in the pre-adoptive home, where she has been ever since. And the only part of that aspect that made that, from the child's perspective, is obviously the removal was traumatic, but when she found out she was going home to pre-adoptive parents, all was well. That was the change, that now the child has expressed the desire to stay where she is.
I'm sorry.
I know.
So it's not substituted judgment anymore. It's the actual judgment of the child that's controlling
Yes, that she
this.
wants to stay where
She's
she
4.
is. Pardon me?
She's 4 years old.
She's 4 years old, yes. She wants to stay where she is. Well, she'll be 5 in December.
I'm sorry.
Yeah, we're going to use more of your...
I'm sorry.
Can you enlighten us in terms of whether or not there has been increased visitation or not?
Child still visits with her mother once monthly.
So it has not been increased despite...
It has
the
not.
And in the normal case, what would happen? I assume that in some cases, counsel for the mother would file some sort of motion with the trial judge, and a motion to enforce judgment, a motion for clarification, a motion to compel enforcement of judgment, something, correct? And nothing has been filed in this case?
Nothing has been filed. The only thing that was filed was the request for review and redetermination by the child in February.
What is DCF's current goal for this child?
I believe that the goal is still concurrent.
I saw that in here. How can you have concurrent goals of reunification and adoption?
Well, but that is exactly the issue with this. My opinion that I would suggest to the court is the appeal was premature to begin with. Because permanent custody, they may call it permanent custody, but it's not really permanent custody. The judge was recognizing that mother had made improvement, had made advances, and basically in 6 months, any of the parties could petition the court for a review and redetermination on that issue. Nobody did that during the year 2022 while this case was pending.
Final question from me, same question.
I'm sorry, I probably won't.
Final question from me, which is this, same one I asked Attorney Duran. Assuming arguendo, purely arguendo, that we decide to reverse this case and remand, what is the appropriate remedy?
I think at best, it's a request for additional findings to address the expert. But my argument on that is that the appellant hasn't presented any case that requires the trier of fact to cite an expert's opinion in their written findings in order.
But in all the years you've done this, have you ever seen a judge just simply fail to address the existence of one of two witnesses in a care and protection case?
Well, what I would say about the expert's testimony is I don't think it's quite as clear-cut as...
Let's assume that's true. Can you answer my question? Have you ever seen a judge, and the judge's findings are robust, they're comprehensive, but there's one glaring omission. Have you ever seen that in your experience? My guess is no, and it's probably just an oversight, which can happen to anyone.
Well, and I'm not even sure that they're an oversight, because I would sort of reiterate my sister's argument, which is Mother got a tremendous break here in terms of the judge had the authority to terminate parental rights then and there.
We have to figure out whether, right, the child's position at trial was, send me back to my mother.
Yes.
The judge didn't do that. And maybe if she forgot this, which I don't think is what happened, but something, right? Maybe it would have come out differently. Even though this looks like a break, mother's brief says, you call it a break, but what she really should have done is sent the kid back. Now, I get that there's no neuropsychological exam, which makes it difficult. I get that she has no housing, which makes calling it current fitness difficult. I've never really understood, since some housing comes with having a child, you know what I mean, it seems like a kind of catch-22 housing sometimes to me. They haven't made that argument.
Can I just ask procedurally? Trial court for child argues mom is fit or mom is not unfit, right?
Right.
Now, as appellate counsel, you're arguing for child, mom was unfit. How do you do that?
Well, that's my point in terms of the ripeness of an appeal, is that here I am arguing facts outside the record. In a criminal case, there it is.
Yeah, I know it's not moot, but it almost seems, right, it seems like we're talking about ancient history here.
Right.
It hasn't been, and of course, we don't accept your factual representations. They're not oath, you're not a witness, da-da-da.
Yeah.
But it almost, right, no one has explained why. I understand why changing again might be bad, but that doesn't necessarily make mother unfit if she's otherwise fit. I don't like this more visits. The whole point of the order was more visits. The whole point, really. Give her an opportunity, and I'm not hearing that happened.
Well, and what the court determined is mother was unfit, DCF had not used reasonable efforts, and going forward, they will...
Have they now, right?
Right, but, obviously, I can't speak for DCF.
No.
I don't know. What I know is, I do have regular, constant contact with both trial counsel and my client. So I'm aware of all the things that have happened. But the substance of this appeal is what happened in that December 2021 ruling.
So let me ask you this. This is sort of a follow-up to Judge Nyman's question, except that his question is the accurate question, because it's about what legally the remedy is supposed to be. If we conclude the remedy is a new trial, how is that any different from the redetermination that was about to take place? Is it the exact same proceeding, essentially?
I would argue that it is, because basically the department is going to have to establish that mother is unfit.
By clear and convincing evidence, currently.
Currently.
Although the child is asking for termination, I assume. That's what, right? That's what you're doing in this redetermination.
Yes, the child's position is going forward. So child was removed in 2019, and it is now, so at some point, the child deserves some permanency. I mean, that's really what we're talking about. And you know what? My client enjoys seeing her mother once a month. Those visits go well.
We've heard really well, shockingly well for a DCF case before us.
But that said, there's been,
Well, we
other
don't
than
know
the
what-
visits,
we don't know what there's-
is kind of where
All
we
right,
are.
but you're saying don't order a new trial. You're saying order some findings. That's going to delay the redetermination.
Well, actually, no, Judge, what I was arguing is that this court should affirm the judge's rulings.
I know that's your argument.
That her findings were not clearly erroneous, that the testimony of that expert was, I would say, ambivalent at best. She said mother could parent with
It's just a
support.
question of whether we can tell from the face of her document that she paid adequate attention to all the facts, including troublesome facts, right? That we've got 100 cases saying that.
Well, Judge, I would actually point out that that Stewart case that talks about troubling facts doesn't talk about troubling opinions, because the trier of fact always has their discretion to believe or disbelieve.
Of course, and if she'd said in one sentence, I heard what she said, but for whatever reason, I don't credit it, or I don't think it weighs more than this other stuff, we wouldn't, I mean, we'd be here, but we wouldn't be talking about this.
I can't find any case law support or statutory support for the proposition that the failure to mention it is dispositive on the issue.
All right, I've taken more
So
of your
thank
time
you,
than,
I know it
than
was-
you've had. Thank you very much. Thank all three of you for your very helpful arguments. These are the most difficult cases we see, so we appreciate the assistance.
Thank you, Honors. Thank you.
The case is submitted. Long pause. How are you, Attorney Baker?
Good morning.
Can you hear us okay?
Yes, thank you.
Okay, so they want you to sit as close to the end of the table as you can so that our video camera will see you, because our arguments are streamed and then archived on YouTube or somewhere. So thank you.
Thank you.
Assuming everything works, we are ready whenever you are. So we will hear now, this is number 22-1103 in the matter of Fred W. Kuhn, and we will hear from Attorney Baker.
Good morning, Your Honor, and thank you for the assistance with my disability. It may please the panel. My client in this case is Donald Kupperstein. For many reasons, I sort of admire Mr. Kupperstein. He's somewhere north of 80. He is an attorney. He still takes some cases occasionally. He has a number of clients that he's worked for a long time. In the case underlying this appeal, his client, a man by the name of Thomas Sheedy, S-H-E-E-D-Y, contacted him, asked him to, told him that he wanted to buy a house out of a probate estate. Mr. Kupperstein said, okay, I'll be glad to help you. He did some due diligence, discovered that there was a lien on the property filed by Mass Health, and proceeded to try to do what would be necessary to clear that lien and to clear the way for the property to be purchased. He made one mistake, at least one mistake. Everybody makes mistakes, but this was a mistake that set off Mass Health, needless to say. he believed that as a matter of law, once the decedent had died and the will was allowed by the probate court, excuse me, that the lien expired by operation of law. He was wrong about that, much to his grievous dismay. So what happened was the Mass Health, and I'm using the term Mass Health for Executive Office of Health and Human Services. It's shorter. But the Mass Health came into the probate court, persuaded the probate judge to set aside. I'm going to back up. I'm skipping something important. Mr. Kupperstein and Mr. Sheedy went to the personal representative, who was the daughter of the decedent, offered to buy the property for a sum of money, plus to pay off an existing, I believe it was a tax lien on the property. They did that. The personal representative, acting in her individual capacity, deeded the property over to Mr. Sheedy, or a trust that had been set up for the purpose. That part of it's a little fuzzy in my mind.
Am I correct, Attorney Beck? I'm sorry to interrupt you, but time runs short. Am I correct that your argument here today has only to do with the automatic stay?
In a sense, it's a little more nuanced than that. What the probate judge did was basically set aside the deed. Mass Health filed a motion for contempt. Mr. Kupperstein came in. The judge was not happy, understandably, I suppose, and found him in contempt, ordered money sanctions. On January 11th, 2018, Mr. Kupperstein filed a petition in the bankruptcy court under Chapter 7. His attorney that represented him at the beginning of the bankruptcy case was, and still is for that matter, a Chapter 7 bankruptcy trustee. So he very experienced and very knowledgeable about these things. As I say, this was filed the day before a hearing in probate court. They went in, the next day they went into probate court with evidence of the filing of the bankruptcy case. The probate judge said, I don't care about no bankruptcy case.
We are well aware of the facts of this case. We've read the briefing, the record, and the long line of cases that predate this one. Mm-hmm. So I want to go back to Justice Rubin's question. My understanding is that this is an appeal of the contempt judgment dated October 28th, 2021. Is that correct?
That's correct.
So to the extent that that is what you're appealing, it seems that you're also trying to re-argue that the bankruptcy stay was violated. And to the extent you are trying to do that, didn't the First Circuit already, the District of Massachusetts, the bankruptcy court, and then the First Circuit already decide that issue?
No, because the issue on the stay point is that what the First Circuit said is that, yes, attempts to collect money are not an exception to the automatic stay. And so what happened in the probate court was that the probate judge allowed the substitute personal representative to sell the property. Mass Health got all the money it was entitled to from the property. Its lien was paid off. Pretty close. I'm not exactly sure how much, but it was paid. So from that point on, all we're concerned with is the Mass Health's efforts to collect the money sanctions. The probate judge
Okay, but
said...
I don't understand, I think my question is roughly the same as Justice Nyman's question, which is this. One day, the Superior Court agreed with your client and said, well, I don't know if this is within the automatic stay or not, so I'm not going to do anything. I'm going to say, go to federal court and find out. In fact, you went to federal court, and I don't remember, you were told that there was a stay in place in some respects and not in other respects, and that's fine. And then ultimately a final judgment, this large, not the contempt, but the $500 and whatever $1,000 judgment enters, and that is appealed all the way here. And that decision says, A, yes, it's fine, we affirm, and it says, Mr. Kupperstein agrees that it is a question for the federal court whether the automatic stay was violated. So what are you doing here? I don't understand. I mean, maybe you have something to say to the federal court, although by 2021 or whenever this entered, I think the bankruptcy was probably done. But I don't understand what we could possibly do for you. We can't say whether you violated the automatic stay, whether the automatic stay was violated or not. That's a federal question, right?
Not necessarily. Let me backtrack just a little bit and fill in. To reiterate, the First Circuit said that the collection of money is not an exception to the automatic stay. The probate judge had every right to order the property sold, to void the deed that the original personal representative had filed. That's fine. That's how MassHealth got paid. But what I'm really ultimately asking here is that the First Circuit said that I'm sorry to keep reiterating this point, but the money judgment, the orders of the probate court allowing MassHealth to collect the money are not correct under the automatic stay.
Go into the federal court then and say that there's a state court that's violating a federal stay and get an order, an injunction to prevent it.
Well, that's not as easy as it seems because...
No, it isn't, I'm sure, because I don't think anyone's going to be interested in this at this point, but go ahead.
Okay, because federal judges don't really want to interfere with the operations of state courts.
But they do when there's an automatic stay and the state court does something wrong, don't they?
They don't say something to the court. They say something to the party before the state court.
In this case, it would be EOHHS and you.
Right.
If they told EOHHS you're enjoined from enforcing this court order, then they wouldn't enforce the court order.
But they did.
So are you separating in the decision? I think I understand your argument.
Okay.
Are you separating out what the probate court judge ordered as far as the lien versus the contempt fine? In saying that, yes, the decision by the First Circuit said probate court, that stay doesn't apply to you as it's to the collection of monies, but a separate issue as far as the automatic stay is the contempt fine. Is that what you're saying, or no?
No, I'm saying that the collection of money is prohibited by the automatic
The collection of the $500,000.
Well, again, we've got a little confusion because it's actually 600 and some odd.
Okay, the $600,000, we know what we're talking about, the triple damages.
Right, but that was the Superior Court's decision. That wasn't the probate court's decision.
Okay, they're both state courts and they're either subject to the automatic stay or they're not, right?
Right, but the Superior Court's decision came after relief, after the bankruptcy judge granted relief from the automatic stay, in part. His order on the automatic stay was that Mass Health could proceed to collect certain aspects of it, but could not attempt to collect the $191,000, I think, that
but that's been affirmed by this court in a prior decision. That judgment is valid.
Which judgment?
The judgment for the triple damages is a valid judgment, right? Because it was affirmed by this court, which said to the extent there's an automatic stay issue, the parties agree that it goes into federal court. So that judgment is affirmed, right?
Okay.
And so isn't this contempt as a result of the failure to pay that judgment?
No.
What is this contempt for?
Because in the probate court, Mass Health said, we want $150,000 for our attorney fees. And the judge granted that as a sanction.
Is the automatic stay still in place?
No.
When did it go out of place?
I don't remember the exact date, but Mass Health and the substitute personal representative filed a complaint in the bankruptcy court to deny him a discharge.
Okay.
Which was granted.
When?
So I'd have to look at...
Before the judgment that's on appeal here?
Yes, I think so.
Then what are we talking about?
We're talking
How
about
can the automatic stay that's been lifted have anything to do with this judgment?
Yes, it does, because between January 1st, 2018, and the date that the judge granted relief from the automatic stay, there was all this action going on, which violated the automatic stay.
But the judgment wasn't entered till there was no automatic stay, right?
No.
The judgment you're appealing, the only one we can do anything about, is the one on appeal.
Right.
The contempt order from the probate and family court. But that was issued after the automatic stay.
Yes, but my argument is that everything that happened between the bankruptcy petition date and the date the stay was lifted.
The things that amounted to the contempt,
yes,
according to the probate and family court, you're saying took place during the automatic stay. And I still don't understand why that's not a federal question.
Well, because the federal question, the federal court would refer me back to this court, back to the state court. I've been doing bankruptcy work for like 30 years.
Sure.
I've seen this happen. Bankruptcy judges have broad discretion to abstain from hearing matters. I have a case now where a creditor filed an action against the sole member of an LLC in Superior Court, while the LLC is in bankruptcy court. I removed it from the Superior Court to the bankruptcy court. The bankruptcy court remanded it back. And that I'm reasonably certain would be what would happen here if I were to go back to the bankruptcy court.
You don't object to paying the attorney's fees, you only object to paying the contempt.
The attorney's fees are the contempt. Well, they are the penalty for the contempt.
I see. All right, your time has expired. We have no further questions. Thank you very much.
Thank you very much. I ask you to find for my client
some things for us. Thank you.
Thank you.
And the case is submitted. The final matter we will hear today is number 22-746. This is and I'm sure I'm going to mispronounce something here, Leone versus Patton. We will hear first from you, Mr. Patton.
Thank you, Your Honor. May it please the court, my name is Attorney Edward Patton. I have been a member of the Massachusetts Bar since 1985, and I am the appellant in this matter. I would like to begin by disclosing to the court that I identify as a straight, white, English, Irish, Christian man. I am 72 years old, suffering from major life-threatening health issues, including 2 types of liver disease, heart disease, diabetes with insulin, and hemochromatosis, a genetic blood disease. I also have neurological damage, including having suffered from a mini brain bleed, and I recently overcame COVID-19. In addition to the above stated, due to my multiple health issues, I am under many doctors' supervision and orders. However, I am able to go forward today with this matter and represent myself, as it is very important and critical to my future well-being. This is an appeal from a decision of the Superior Court for a final judgment decided by Judge Mulligan, which I received in the mail on a verdict slip in an action dated November 4, 2021, that states that I breached a contract. This judgment is contrary to the original verdict slip dated October 29, 2021, where Judge Mulligan clearly showed and stated that I did not breach a contract. The November 4, 2021 judgment on the verdict slip had been changed. This change was blamed as a scrivener's error, which was somehow brought to the court's attention unbeknownst to me, where I was completely not notified and therefore was not given an opportunity to be heard in opposition.
In opposition to the finding of a scrivener's error?
To the change of the verdict, yes.
I mean, I will say, it does say damages were sustained. I understand, I mean, there's something on the face of this that suggests it could have been a scrivener's error, because it includes damages and talks about prejudgment interest, and if you'd won, there wouldn't be any damages or prejudgment interest.
That's correct.
And this was not a jury trial, correct? This was a
No, this was,
trial?
pardon me, Your Honor, jury waived.
So presumably, the judge, Justice Mulligan, was serving not only as the judge of the law, but also the judge of the facts, and she alone would render the verdict, correct?
That's correct.
So is this a new argument? Because I'm not sure I was able to understand that from your written brief, that the error here, if I'm understanding your oral argument, is not having an opportunity to be heard to challenge what was called a scrivener's error.
That is one basis of a challenge, yes, Your
Is
Honor.
that new?
Um,
'Cause I didn't see it in your brief.
Well, it is new with respect to this particular case.
Can you just explain to me, so one is the Scribner's error that you believe you should have had an opportunity to argue or to be heard, correct?
Yes, Your Honor.
What are your other legal challenges?
My other legal challenges are, one, the fact that the appellee engaged in fraudulent behavior with respect to the amount of money that she had access to under the domestic relations pattern. She had engaged in securing additional money during the Nisi period.
Can I interrupt for a moment?
Certainly.
So your argument is that the judge was clearly erroneous in her fact-finding role? Is that what I'm hearing?
Yes.
Because there was testimony about the appellee's financial situation and the information that was provided. And so was the judge able to determine and credit or not credit the testimony as to whether there was an intention to defraud?
There was evidence, substantial evidence, with respect to the genesis of appellee's loan from the World Bank for Savings.
I understand your argument, but I guess my question is, how was the judge clearly erroneous in her findings?
Her findings were totally apart from the quantum of evidence that was presented. The appellee took the stand, was examined, cross-examined, went through her history of securing the loans, her not reporting that additional income in the context of the probate proceeding, no disclosure on any financial statement of a benefit of $725,000.
Okay, here's what I don't understand. I read your brief. Let's leave aside the fact that they're at two different times. You're saying that on the form that she submitted to the court, she said a low income, and when seeking the mortgage, she stated a high income.
That's correct.
You're saying that necessarily means she was lying on the low one. But maybe she was, lying is too strong, because of course she testified that she didn't even look at these forms, but let's say the one that's inaccurate is the high income, which is what the judge found. I mean, I get the logic. The logic is both can't be true. But she testified, yes, the loan documents are not true. She also went on to say, you know that I'm like a teacher or whatever, there's this other stuff. I don't have that kind of money. And maybe she does, maybe she did, whatever. But the judge found, yeah, that's right. These are the inaccurate ones, the mortgage ones. There was no fraud in the court documents, and you're not the bank, so you can't come in and say, oh, I want my mortgage back or whatever, because these were inaccurate. So I don't understand why the judge isn't free to credit her testimony that the inaccuracy was in the loan documents, not in the court document.
Well, another component of this particular proceeding was a motion for summary judgment that was before the court in April and May of 2019. That matter was heard, all right, by Judge Wilkins. And the judge wrote an opinion, all right, and I assume you've seen that opinion, and he was certainly convinced that there were improprieties sufficient.
Denial of summary judgment just means there are genuine issues of material fact.
Correct.
There aren't findings of fact, just
No.
genuine issues.
Correct.
And then subsequently, there was testimony, and the judge concluded the inaccurate one is the mortgage document. I understand you don't believe that. I get that. But how can we reverse a judge's finding based on evidence heard by the judge, credibility determination made by a judge, testimony we haven't heard? Don't we have to, isn't the usual rule that we have to defer to that finding of fact?
Unless
Accept it?
Pardon me, Judge. Unless clearly erroneous.
How can it be clearly erroneous when it's what she testified to?
But
That's actual evidence, sworn evidence, that the inaccurate one is you may not believe it, you may find her incredible, but the judge found her credible.
But she also hid the money. She hid
Unless
the
there
money.
was no money.
Pardon me?
Unless there was no money, and she just submitted something saying there was to get a mortgage, which unfortunately is something that has happened in the world, particularly back then.
Yeah. But the record shows that she did get the money.
$700,000. Oh, the loan, you mean?
Yeah.
The loan, you're not entitled to her loan. She owes that. That's a debt she has. How does that help you?
Right. But the point is that during the nice-side period, all right, the nice-side period for this action began on July 13 of 2005. All of this transactional activity regarding the loan, regarding securing additional money, all occurred during that 90-day period. She was obligated.
So what? She was obligated to say, I have further debt? Because if she gets the loan, she has more debt than you thought, not more assets, right? The loan's an asset of the bank, it's a liability to her.
That's correct.
All right, so she has more liabilities than you thought. Liabilities don't help you, right? I thought your argument is she has more assets than she told you, not that she has more liabilities than she told you, right?
Yes.
So how are you injured by not knowing about the loan that she got during the NICE period?
Because Rule 401 of the probate rules require that a litigant disclose all assets and liabilities.
How are you injured?
How am I injured? Because the calculation of the amount of alimony that I was ordered to pay is dependent upon assets and income of the payee.
I agree with that, but now she's got further liability, which might make it won't make your alimony go up because that's neither an asset nor income. But it's not a new asset she has, it's a new debt. Now, I don't know if she can afford both the mortgage and the, whatever else she's doing, but her having more expenses doesn't help you.
Well, again, the greater the amount of assets
I agree
that she had drives the amount of alimony.
But you agree that the loan is not an asset.
The money generated by the loan as to her, once she received it, is certainly an asset.
If I
There's an
borrow
offsetting.
money, that's an asset of mine, it's a liability of mine.
It is a liability but the actual cash is an asset.
So just as we're coming close to the time, I want to make sure that I understand and comprehend all of the many arguments that you have before the court. The first you've addressed is a Scribner error. The second is your position that fraudulent behavior. And is there anything else that I'm missing as far as, are those the two issues properly before the court?
Yeah. There's the issue of the material change of circumstances.
Where is that in
It
the
is,
brief?
it is pled within the context of the trial. This action.
In the context of your appeal, I'm sorry, in the context of your appeal, where is the argument of material change of circumstances?
Pardon me, Your Honor.
I don't see those words in your brief for what it's worth.
In the brief, we talk about the reduction of income that I was suffering at the time. Right? I was essentially broke, and I still am, quite frankly. And that the reduction in income and the failure of my law practice were clearly before the judge in the context of the testimony. That's there, it's in the brief, it's in the appendix, it's in the transcript, and that resulted in a reduction of my income. It's a material change of circumstance in that respect. The other significant issue is the issue of cohabitation.
Okay, we're going to have to leave it there because your time has expired, but I certainly understand your claim better having heard you than I did coming in. So thank you very much for a very good argument. And we will hear now from Attorney Capozzoli.
Thank you, Your Honors.
Good morning, members of the panel. I'm actually Mary Ann Driscoll. I'm doing the oral argument today.
You are.
And Attorney Capozzoli, however, is in court with our client, and I'm pleased to be here to represent Anna Leone. These parties were married. They were divorced in 2005. They entered into a separation agreement totally voluntarily. That became a judgment of the court, except that the alimony provision did not merge with the judgment of the court. It was regarded as an independent contract. Now, Mr. Patton paid alimony for a couple of years, and in September 2014, he stopped paying it. That is absolutely uncontroverted. He says it in his pleadings several times, and then before he stopped paying it, he brought a complaint for modification in the probate court. And all of the issues that he raised today, such as his inability, his circumstances, whether there was a fraud, and whether the cohabitation issue, all of those things were raised in the probate court hearing. The judge ended up dismissing his complaint for modification. That complaint for modification was appealed by him to this court, and this court rendered a decision on it in 2019. when Judge Wilkins, who was the motion judge in the Superior Court, I should say, while that case was pending, Attorney Capizoli brought a breach of contract action in the Superior Court. There were joint cross motions, rather, for summary judgment. Judge Wilkins heard them, and he did allow Mr. Patton to raise the issue of fraud. It was limited to that. He did not.
These arguments about the loan cash being an asset of your client, those were not raised in the proceeding that is on appeal.
Yes, the decision of this court addressed the issue of fraud, actually.
Okay.
I
have it in front of me, so.
I thought it was interesting in the prior case, Your Honor, that there was an issue about a case that had already been decided by this court. And this court actually decided in July 31st, 2019, affirmed the decision of the probate court. And that fraud was one of the issues that was addressed at that time. Judge Wilkins, when he decided the cross motions for summary judgment, didn't have the benefit of that decision. It hadn't come down yet. That was in, I believe, May of 2019. Now, as to the issue raised by Mr. Patton as to the scrivener's error.
Well, wait. I just looked at our previous decision.
Yes.
And of course, that's about a question of whether the modification should have been allowed on the basis of fraud, and there's a 1-year limit and so on. The question in this case, before we get to scrivener's error, as I understand it, was there a breach of the alimony agreement by failure to pay, and was it excusable because of fraud?
But
what I'm asking is, today he has said, and his brief says, during the Nisi period, your client received, by getting these mortgages, a bunch of cash. And somehow that should have been included in the calculation of his alimony obligation. And I guess that could be part of a defense to a breach of contract claim. I don't really know enough about this. And so I'm asking you first, was that raised below in this matter? This question of treating the cash as somehow an asset of your client.
In the Superior Court matter?
Yeah.
Yes.
It was raised?
Yes, it was.
Okay, and what is your answer? I understand your answer to the fraud question, which I think is, it's true that these loan documents state a different income, but they are wrong, not what was submitted to the court. That's your position, right?
Correct.
Okay, but what about the cash that was received, admittedly from a loan, during the Nisi period? Is that relevant to the breach of alimony claim?
No, it isn't.
Why?
Well, first of all, the loan that she received, she used to purchase a vacation home in Truro.
Okay, so now she has a big asset, a vacation home in Truro.
This was in 2005, right after they were divorced. It may have been
during the Nisi period.
It may have been during the Nisi period.
Okay.
But nonetheless, it was after the separation agreement had been filed. And Mr. Patton was well aware of the fact that she had purchased this home.
Well, he says it wasn't. That's a factual question. I don't know the answer to that. Did the judge find that he was aware of it?
I believe it's somewhere in the decision that there's a testimony. Yes, well, in Ms. Leone's testimony before the Superior Court judge, she said that Mr. Patton was well aware of the home because they had a child in common, and when Ms. Leone and the child would stay at the house in Truro, Mr. Patton, who lives in Provincetown, would have visits parental time with the child.
Did the judge find anything about either the need to have filed an updated financial report during the Nisi period, or whether that was in any way had any bearing on the breach of alimony agreement claim?
Are you asking about the probate judge or the
judge below in this matter?
In this matter, the Superior Court judge? No, she simply found that there was no fraud, and that was because they agreed to the verdict slip approach rather than the...
When you say, I'm sorry to interrupt you, but when you say the judge found, the judge had a verdict slip.
Right.
And then the judge issued an exhibit to the verdict slip.
This was done under Rule 20?
Prejudgment interest, correct?
This is one of the, so is this a Rule 20 proceeding below? Where they forego findings of fact?
Yes, she asked them if they would be willing, so that's in the transcript as well. She asked them if they'd be willing to forego findings of fact and just have her submit a verdict slip, and they said yes.
Doesn't that limit the scope of our appeal?
Pardon me?
Don't we have a different standard of review in Rule 20 cases because there are no findings for us to review for clear error? I thought there was some lower...
I don't know the answer to that. I didn't explore that. I was not the attorney who wrote the brief.
We'll figure it out.
Wrote the brief. But they both agreed to proceeding that way, and they both approved the verdict slip. She had it drawn up before she made her decision, and they both stipulated to it. So, I mean, the finding that she made is that there was no fraud, and that Mr. Patton was liable in the amount of damages according to the her exhibit. And then as to, if I can get to the scrivener's error, there was a third page of the verdict slip in which the scrivener's error was corrected, and it was signed by the judge. And all I can say about that is that we're all human and we all make mistakes, and this was caught and corrected by the judge herself. And I don't think that Mr. Patton was in any way entitled to a hearing on the issue of a scrivener's error. And so I just said that there were basically two issues before the court. Did Mr. Patton violate his obligation to pay alimony? And the answer is yes. He admits that he stopped paying the alimony. Did Ms. Leone commit a fraud? The answer is no. The judge found that she did not.
So those were the issues at trial. The issues on appeal, maybe.
And the other issues that he raises about his financial condition and such, those have all been addressed by the probate court, in the probate court hearing. And he also raises, I think in the reply brief, he raises the alimony statute, but he never argued that before the probate court, although he did argue the theory of countervailing equities, but the judge did not find that he was entitled to the benefit of that doctrine. So I would ask that the court affirm the judgment of the Superior Court, and if you have any other questions, I'd be happy to answer them.
Seeing none, thank you so much. An excellent argument that has clarified things for us, for both of you. The case is submitted. This brings us to the end of today's session. I would like to thank the court staff for their assistance and particularly the court officer for his assistance. And we stand in recess.
Thank you, Your Honor.